Yes.
May I plead your lordship? Lordship, item number 73 of supplementary list. The matter may be adjourned and fixed on Monday, your lordship. The HRS Chaudhary senior counsel supposed to appear due to illness. He is under treatment in Kolkata, your lordship.
73.
73 of supplementary list.
What about 74? That is also him.
74.
Okay, that must be some other council.
CD may be retained, interim may be continued.
All right, Monday. CDB retained. Interim.
Published.
Please, your lordship. Lordship, in connection with item number 19, lordship, I have filed an additional affidavit. Lordship is not being in. Kindly may issue requisition, lordship. Yesterday I have filed, lordship. Item number 19. Published.
With the consent of the other side, I beg to mention item number 49 and 50. 49 and 50, my lord. My lord, an IA has been filed, my lord. 2 weeks time may be granted to file the rejoinder.
In 9. This with or not with? Yeah? On the prayer of learned counsel for the respondent
Petitioner, my lord.
petitioner. 2 weeks further time is granted to file rejoinder to the IA filed by the respondent. Again on.
May I please, your lord?
My lord, the interim order may be extended, my lord.
The next date of.
I beg to mention item 70, lordship. With the consent of other side, I may be allowed 2 weeks time. 70.
You're for
Respondent number 2, please.
the prayer of learned counsel for the respondent number 2 and with the consent of the petitioner side. Is the matter again on?
Published.
May
Yes.
please, your lordship. I beg to mention item number 66. Kindly pass over it for today and fix it on next week. Obliged.
Please, your lordship, I beg to mention item number 31. Pattern will fix on next week, lordship.
31
31,
next week.
next week.
May I please, your lordship? I beg to mention item number 37. Maybe as on 2 weeks, lordship.
Hearing is there.
Skin copy is there. Better, lordship. Skin copy is there, lordship. So the personal difficulty of the exponent, lordship.
No, any interim is there.
No, it remains.
37.
37.
All right.
May it please your lordship, with the consent of petitioner, I beg to mention item number 12 of the daily list for 1 week.
In this case, I am appearing for the petitioner. No,
Item 12.
yes, item 12 was. After 14th lordship, can it be fixed? Elections are there.
Prayer of learned counsel for respondent number 2.
Yes, fine, yes.
Matter again on.
But
May it please, your lordship. A lordship, I beg to mention item number 33. The interim may be extended.
CD is there.
CD is there, madam.
Yes, your lordship.
Friday.
May I plead, your lordship? I beg to mention item number
Yeah,
34,
next.
lordship. CD not received, lordship. Interim is there, lordship.
Item.
Item 34, lordship. Interim is there, lordship. Interim may continue.
He did not receive list again of strength. Tell him to pass. To continue till next.
Obliged.
may I please your lordship? I beg to mention item number 22, my lord. In this case, my TCR received my lord POCSO, lordship, my lord service detail. What is awaited, my lord. I have inquired with my lord last repeat. Next week, lordship.
Service awaited, not complete. Respondent number 2, await, list taken on.
One more pair also, item number 65. Just call for my lord, CD, my lord, inquired. Contact interim lordship. Let me go complete.
65,
Lordship.
he did not receive, list taken on so and so interim past.
Maybe continue. Lord, item left.
May I please your lordship, I beg to mention item number 21. So lordship, kindly matter may be adjourned for a week.
21, okay, next week.
Your Lordship, with reference to item number 43, I would like to mention, since diary has not been received, Your Lordship, a date may be fixed.
43,
The item number 43.
yes. When?
He is not on interim, Your Lordship, short date.
Yes, next.
May I please, your Lordship, I beg to mention item number 46, Lordship, case there is not received in this case, Lordship. I am not on 46.
Already.
I am not on interim, Lordship. Short date may be given, Lordship. Even 10th, Lordship. 10th August.
Yes, next.
I beg to mention item number 16, Your Honor. Kindly assume this matter for the.
Right, 2 weeks.
Bless you.
On instruction of my client, Lordship, I beg to I want to withdraw this case.
Head of Mr. G. Chamua, learned counsel for the petitioner. Matter is dismissed on withdrawal.
Deeply obliged, Lordship.
Item number 1.
Wait, please, your Lordship. Page 10 is the FIR, my lord. Lordship has fixed the matter today, my lord. After going through the FIR, my lord, actually, my lord, the allegation is that, my lord, one RRU, my lord, one remote has been stolen, my lord. And in the FIR itself, it is written, is it recovered, my lord. Page 10, my lord, it has been recovered. Actually, I was the driver, my lord. Some persons hired my vehicle. And when, my lord, they heard hue and cry, they ran away, I was caught, my lord. I'm behind the bars for 27 days now.
It is not received, madam. It was caught red-handed.
Yes. This is come up for motion.
Yes,
My lord ought to have come for bail hearing, my lord.
come for bail. That is why some.
Huh?
Could have been bail hearing, my lord.
Shri Anand.
When can you get?
On my lord,
Friday, Lord, 27 days in custody, man. So,
Monday.
on my lord.
She did not receive, list taken on Monday.
bless my lord.
Well, page 12 is the FIR. POXO is there, my lord.
CD notice to respondent number 2.
The under trial matter, Lordship.
This year.
Obliged.
10 copy this year.
20.
May I please, your lordship? Lordship, POCSO, lordship. And victim and informant was cross-examined, examined and cross-examined, lordship.
Same order.
Oblige, your lordship.
21st.
Wait, please, your Lordship. Lordship, my senior is at Lex at another court. Take up the matter after some.
What is this UAP? Okay, let him come.
Oblige, my lord.
May I please your lordship. Subsequent matter, my lord, PROCEEDINGS 8.
Same order.
TCR may be.
PCR and notice to respondent number.
May I plead your lordship? I am behind the bar for last 60 days. And total phone number of persons has been arrested earlier. 3 of them got bail. Your lordship may go to page number 29. The last order. It is very clear that section 118 and section 109 is not applicable in this particular matter because there was no injury and there was no weapon that has been used. And it is very clear from the forwarding report also. In page number, forwarding report is page number 23. Round of arrest. I have been arrested for a reason that I have been shown in the CCTV footage, and it is confirmed by the prime accused, Raj Roy, who has been granted bail in June 23. It is more than 40 days back, almost. And this is the only allegation against me. And I am the last person who is behind the bar.
So PP, all have gone.
Lordship.
All others have been granted.
Others have been granted bail, my lord. And my prayer, my lord, therefore CD, my lord.
Today 60 days.
60 days.
We saw the CD just few
No.
days back.
No.
What is your name?
Are they?
No.
29.
Present petitioner, Gaurav Roy.
CD will be perhaps here, my lord, because 31/7 is the order passed. May I pray day after tomorrow, my lord? So if subject to lordship's convenience, my lord.
You can get it. If it is there, maybe you can get it in the second half also.
Lots of CDs are there. Otherwise, to go through, my lord. Several cases are there, my lord. Right, my lord.
Your lordship, already 60 days is there.
Offense is 60 day or 90 day.
If we consider section 118 subsection 2, that is grievous hurt with sharp weapon, then it can be. But it is very clear that no weapon has been used from the FIR also and from investigation also.
All right, tomorrow.
My lord. Right. I'm obliged.
Tomorrow.
I'm obliged.
Public.
Even if it is 60 days, it is only tomorrow that your right will accrue. Learned additional PP submits that the CD may be available since it was last placed before the court on 31st.
1118 is 90 days, my lord.
Yes, 31/7/26. Hence, list the matter again tomorrow. And run it. Additional PP shall place the CD if available.
Yes.
Obliged.
May I please the lordship? But the petitioner, my lord, he is a student of BBA, my lord, Business Administration, my lord, and he was arrested, my lord, on the basis of FIR case 10, my lord.
কি case? Yes.
And 13 and 14 of gambling has been added, my lord. Punishment is 3 years. Merely on suspect, my lord. He has opened a business account and on the date of occurrence, my lord, KYC updation was doing, my lord. But then the police appeared and picked up them. Further, my lord, custodial intention may not be required. And in similar case, my lord, this all court held that 8 days, 10 days, my lord, is sufficient.
Yes, only
Yes.
suspicion, nothing is there. Just,
Yes. Para 4 minus 8.
and the mobile is with them.
Mobile phone of Tafikur Rahman, several suspicious transaction messages, screenshot, WhatsApp, preliminary examination of contents reveal chats and transactions relating to online gaming and betting activities.
So suspicion. How long can you hold on suspicion only?
Upon my lord, yes, meaning of the my lord, WhatsApp messages and communications, my lord.
17 days behind the bar.
Reveal chats, my lord.
Third learned counsel for the petitioner, this is an application under so and so. As per the FIR, acting on source information, the police visited one restaurant on 18/7/26 and found 3 persons therein, including the present petitioner. And upon a scrutiny of his mobile phone, certain suspicious transactions, screenshots and WhatsApp communications were noticed, and the digital contents revealed chats and transaction related messages apparently connected with online gaming and betting activities. It further appears from the FIR that the petitioner has been arrested purely on suspicion regarding his involvement in betting and gaming. Here, the petitioner has learned additional PP has prayed for calling for the CD. However, having regard to the fact that the police had sufficient opportunity to interrogate the petitioner and the mobile phone has also been seized, as well as the fact that the petitioner is being held behind bars for the last 17 days only on suspicion. I am of the view that the petitioner to be released on bail. Accordingly, the prayer for bail is allowed. Crucialities provided that the petitioner shall continue to cooperate with the investigation and not try to tamper with the evidence.
Judicial magistrate verbatim. Okay.
May I please your lordship? Lordship, this is a regular bail application filed under section 486 ENSS. Lordship will find the FIR at page number 12. Lordship, my name is not there in the FIR, and the basic allegation against me is this, that I have been arrested purely on the ground of suspicion that I am a linkman of Alpha and I'm helping some Alpha cadres in extorting money. Lordship, I have been arrested on 24/6/2026, and since last more than 40 days, I am behind the bar.
CD.
Lordship, a date may be fixed. Lordship.
14, my lord.
Lordship, pass over the kindly pass over for
14,
pass over the time being, Lordship.
Happy job. Unless it's a pre-arrest bail, my lord. Your lordship will kindly come to my lord the FIR at page 37, my lord. In fact, my lord, civil dispute has been given criminal color in this case, my lord. Page 37. 2 and 3, my lord, before your lordships, my lord. My lord, your lordship will see that with respect, this is to inform you that on 35/2026 at 2 p.m. The above mentioned accused persons by breaking lock and wall of my godown situated at so and so, stole away so and so, so and so. The eyewitness reported to me. My lord, in fact, my lord, at 2 o'clock.
Theft, what is civil about it?
In fact, I will come to that, my lord. In fact, my lord, this, my lord, person, the informant Madhusudan Sohan, my lord, there is a civil title suit pending, my lord. Your lordship will kindly come to my lord, page 10, my lord. Page 10, my lord. Your lordship will see plaintiff number 1, Srimati Ram Sukhia. Page 10, my lord. It's a title suit pending, my lord. And this informant is, my lord, he is related to this person, my lord, plaintiff number 1. And your lordship will see that page 11, that is the principal defendant, my lord, Sri Ramadhar Singh Shatri. So this is how, my lord, there is a civil suit pending, title suit number, my lord, TS case number 145.
What is Ramadhar got to do with this case?
Yes, my lord, I am coming to that, my lord. In fact, my lord, these petitioners, they are running a shop, my lord, in the premises, my lord, where this title suit, my lord, 145/2021 is the subject matter, my lord. In fact, my lord, this petitioner number 1, he got, my lord, through agreement, my lord, one rent, my lord, one rent, my lord, one room, my lord. And that is your lordship will kindly come to, my lord, this agreement at page 28, my lord. Page 28, my lord. Or page, my lord, page, copy of the agreement, my lord, page 28. This is, my lord, one Rajesh Singh. He is the, my lord, son of this, my lord, principal defendant. And, my lord, this Mustaq Ahmed, my lord, this is the petitioner number 1, my lord. So by this agreement, my lord,
is Madhusudan Chauhan.
Madhusudan Chauhan, he is the, my lord, related person of this plaintiff number 1. In fact, my lord, dispute is, my lord, with regard to the land, my lord, and there are some tenants under him, my lord. This is, my lord, plaintiff number 2, 212, and, my lord, performer defendants, they are the, my lord, tenants under him, under plaintiff number 1, my lord. So here, my lord, this Rajesh Singh, he is the, my lord, son of the principal defendant. In fact, my lord, he is the owner of the land, my lord, and he has given on agreement, my lord, the room, my lord, that is, my lord, given on rent by Rajesh Singh to this petitioner number 1. That is a Mustaq Ahmed. You also will see Sri Rajesh Singh so and so, Mustaq Ahmed, as it above so and so, whereas the first party is the owner of a room measuring so and so, situated at Boragaon, Sareli, so and so, by dark number 281, PP number 20. This is the schedule C of the plaint, my lord. So this is the address, my lord. Now, my lord,
Now this deed of agreement witnesses follows. One, that the said room should be used by the second party for the commercial purpose stock business. This is by the petitioner number one. That the duration of this agreement is for 5 years, which is effect from 2/12/2025. It is still in operation, madam. Three, that the said agreement will be extension after the execution of 11 months of every year. That the second party paid rupees 1 lakh to the first party as security money and the same accepted by the first party. That the second party shall pay rupees 1,000 as monthly rent for them. In fact, this is continuing, my lord. My lord, where my lord this present my lord allegation is there of this my lord FIR, my lord. Then you'll also will see one my lord in the same time.
Okay, anyway, your FIR, this was lost 2 months ago.
Yes.
So you can wait for some
Like
time.
you'll also will kindly see FIR from the FIR itself, my lord, at the day hour 2 p.m. my lord. If it is possible to my lord breakdown of wall and lock and key, my lord, then huge amount of this, my lord.
We have a term for that, daylight robbery.
Yes, you'll also will see, and that is after 4 days. In fact,
Anyway,
not the day very itself, my
You
lord.
have come after 2 months. You can
In
wait-
fact, I approached
wait
the
for a
learned-
week.
Hello?
Yes. What?
In fact, we approached the learned court below in the meantime, my lord. That has been rejected, my lord.
Another reason why we should not grant interim. Yes. CD.
And that may be 14.
Lordship, the allegation is that false promise of marriage and the allegation of grave, Lordship. The FIR is at page 17, Lordship. Lordship, there was a acquaintance between the petitioner and the informant. The informant is aged about 40 years, Lordship. And I am 25 years old, Your Lordship. And at the initial acquaintance's time, Your Lordship, the petitioner did not know about her age. And later on, while he came to know age, and he also found out that she already married and she has got a 17 to 18 years old daughter. Thereafter, Lordship, the petitioner did not continue the relationship, and therefore, on grounds against the petitioner, the informant lost the instant FIR. Your Lordship, in the FIR, the incident, alleged incident took place 2/5, and she lost the FIR on 22nd of June, Your Lordship. And there was a Lordship, there are some WhatsApp communication which shows that even the petitioner was threatened by the informant itself, Your Lordship. Lordship, may I take your Lordship to the FIR, Lordship, at page 17, Lordship.
Yes, FIR we have seen. What else do you want us to show?
Lordship, at page 23, there was a communication between the petitioner and the informant. May I read, Lordship? Why didn't you call? Let us meet tomorrow. You had mentioned so-and-so, so-and-so. Would you try it? After seeing so-and-so, I cannot hold my mind. I have been craving it so much. Please try to understand me. I will pay for everything. You don't have to worry about anything. I really want it. In the middle of this busy life, I am just looking for a little happiness. After all, life is uncertain. Please reply, dear. Lordship, thereafter, while I have not ready for that, the reply of the informant. The thing I had refused before. Today I actually wanted it.
Where have you stated she is married?
Yes. Lordship, at page para 5, Lordship.
Yes, PP.
That the case there was maybe call for, my lord, because as per the FIR, my lord, she was raped without her consent, my lord.
Lordship, otherwise, there are some messages written at page 27, the type copy, that she
Without her
said
consent,
that you will have to face the consequences. And she also threatened with my mother name, sister name, at page Lordship 33. She threatened everything. Lordship, I have all documents with me, Lordship, the communication and all. I'm ready to go before the IO to record my statement, Lordship.
From dispute PS case, my lord, and the FIR was lost on 22/6/2026, my lord. Now, my lord, he has come, my lord. Let the case there be called for, my lord. Any date, my lord, may fix.
What is the date of the FIR?
22/6/2026, my lord.
Lordship, in the FIR, the informant said the alleged incident took place on 2/5. I am ready to cooperate with the investigation, Lordship. I may be, some protection may be granted. I may be go before the IO, Lordship, to place all the documentary evidence.
It heard learned counsel for the petition and learned additional PP. Application under so and so. The allegations as reflected in the FIR are that the informant, who is a 40-year-old lady, came into acquaintance with the present petitioner through social media, and on 02/05/2026, the petitioner took her to a hotel in Gauhati on the pretext of discussing some important matter, and thereafter established physical relation with her against her will, threatened to kill her if she disclosed the alleged incident to any other person. Full stop. Para. Learned counsel for the petitioner submits that as alleged, the petitioner, who is a veterinary doctor aged about 25 years, came into acquaintance with the informant through social media, but later on discovered that she is much older than him, and further that she is a married woman and the mother of a 17-18-year-old girl, and thereby he broke the relationship. The learned additional PP submits that the CD may be called for. The FIR was lodged on when?
Well, it was
22/6.
registered on 22/6/2026.
26. Perusal of the documents annexed to the instant bail application, including the WhatsApp messages between the government of the petitioner, indicate that there existed a relationship between them. And in one of the messages, the informant apparently threatened the petitioner with consequences in the event of a breakup, which is dated 28 April. That is prior to lodging of the FIR. Full stop. Having regard to the above, as well as the statements made in the bail application, supported by an affidavit regarding the marital status of the informant, is provided that in the event of his arrest, the petitioner shall be released on interim bail of ₹50,000 with a surety for like amount to the satisfaction of the arresting authority in connection with the aforesaid case. It is further directed that the petitioner shall appear before the IO within a period of 10 days from today, and that he shall not try to influence or intimidate the victim or the witnesses acquainted with the facts and circumstances of the case. List again on
21-8. 21-8.
Obliged, Lordship. Please, Your Lordship. Your Lordship, 482 PRS bail application. The FIR is at page number 10, Your Lordship.
Your
Lordship, only section 13(1) is applicable here, Your Lordship, and I was the customer, Your Lordship, not the shop owner, as because only one weighing machine has been seized, Your Lordship. In the FIR, it has been said that only one weight machine, Your Lordship. Moreover, I'm permanent resident, I'm ready to cooperate, Your Lordship. And all the material evidence has been seized, Your Lordship, in the present case, Your Lordship. And only section 13(1) is there, not anything of Prevention of Cruelty to Animals Act, PC Act, nothing in PC Act, Your Lordship. I was only the customer, Your Lordship. I'm ready to face the trial. I'm ready to cooperate, Your Lordship.
how many days?
Your Lordship, pre-arrest bail.
This is pre-arrest. It says in the shop of Nasiruddin, it says your shop. You're Nasiruddin.
Shop of Nasiruddin, but no evidence has been given here, Lordship.
The evidence we'll see in the case diary only.
Your Lordship, interim till then, I'll appear before the IO, Your Lordship.
So named in the FIR, you are the, how can we grant you interim, just like that? Okay, give a date.
18 to 18. 18.
May it please your Lordship. Here, my lord, before coming to the case, my lord, Lordship may kindly turn to page 16, my lord. Page 16, my lord, by virtue of an power of attorney, my lord, no. I took my lord, Mohan the elephant, my lord, from my lord, Assam to Rajasthan, my lord. By virtue of an my lord, power of attorney.
So what happened? You had the power of attorney to handle the elephant.
No, my lord, page 48, my lord. Page 40. As soon as I landed in my lord, in Rajasthan, my lord, my elephant, the case was registered, my elephant was seized, my lord.
Page?
Page 48, my lord. And page 49 is the Hindi version, my lord.
Yes.
Page 51 is the FIR, my lord, and page 52 is the FIR, my lord, in Rajasthan, my lord. Then, my lord, eventually, my lord, I was granted bail, and the page 64 is the order of the Jimma order, my lord, of the elephant, which was granted by the court there, my lord, in Rajasthan. Page 64, my lord. Jimma of the, my lord. Here the case has been discussed, my lord.
All right. Then what happened?
Then, my lord, what happened, my lord? The elephant was handed over to me, my lord, to us, my lord. Then, my lord, I have lost the case against the persons, my lord, who have cheated. Actually, my lord, the elephant is not stolen elephant. It is their elephant from Loknath Bora. But, my lord, the transit pass which they have given me, it was fake, my lord. And accordingly, I have lost the case against them, my lord. And, my lord, page 72, that they have given me a false pass, my lord. Now, my lord, the lordship, why I am apprehending, my lord, page 91 and 92, my lord. Now, my lord, it may be treated as a second case also, my lord, because already a case is there in Rajasthan, my lord. Page 91 and 92, my lord. Summons has been issued to us, my lord, father, son, my lord, that we should appear, my lord. On that day, we did not appear out of apprehension, my lord. Page 91 and 92. And we have lost the case, and my lord, those persons, my lord, who has, well, that challan is fake, my lord, the transit challan. So, my lord, I am ready to come, my lord. I will come from Rajasthan to Assam, my lord. I am ready to, my lord, give my statement, my lord. I am record my statement, cooperate with the investigation, my lord. But, my lord, we apprehend, my lord, that, and it may be treated as a second case or second affair, my lord, because already a case is there in respect of the same incident.
Yes.
Yes, my lord, here also, my lord, one case is registered, my lord. So I have to take.
I think it is already from the what has been observed by the learned courts at Rajasthan. So the elephant is domesticated. That was why Jima was granted. The thing was that the transit thing was that was fake, and that was issued by this Bora fellow.
Yes, my lord.
Yes.
We have lost the case also there.
So in respect of that, he has lost.
So,
So
but
the
what
original
lordship-
forest offences under which this notice has been issued do not appear to be attracted, since it is a domesticated animal.
But let him obtain instruction, tell them, my lord, I may be directed to APR, my lord, with some protection.
Because here, my lord, some
And it is a
forest
second-
offence may be
Anyway, his
committed.
arrest is probably not necessary.
Yes, my lord.
We'll
That
let him
will-
appear.
But, my lord, investigation,
Third learned counsel for the petitioner and special PP Forest Department. This is an application under so and so. The petitioner has received a this dated 18/6/26 from the Divisional Forest Officer, Vishwanath Wildlife Division.
Two notices, my lord, father, son, both, 91, 92.
Same date.
Same day, same day.
Petitioners have received notices dated in June. Seems. Asking them to appear in connection with offense number so and so, page 91 top offense number. Right. So transpire that the elephant in question was earlier seized by the police in Rajasthan after being transported from Assam the month of February 2026, but subsequently the court in Jaipur had granted Jima of the elephant to the petitioners as it was a wild animal. Full stop. Para. Call for the records. In the meantime, it is provided that the petitioner shall appear before the IO within a period of appear before the DFO Bishanath Wildlife Division.
Divisional Forest Officer, Bishwanath Wildlife Division.
Bishanath Wildlife Division within a period of 10 days from today.
That will be 14 days, now they will come from
15 days from today. In the event of their appearance. And case of their arrest, they shall be released on interim bail of 50,000 with 2 securities of like amount each to the satisfaction of the arresting authority. Place the matter again on so and so.
obliged manner. No, let him also obtain instruction money, obliged money. 21 hours.
May it please your lordship. My lord, this is an application under 528 for quashing of the FIR along with the charge sheet. The petitioner, he himself is a sub-inspector of police. My lord, the FIR that was lost is at page, it starts at page 13, the relevant is at page 15. Your lordship will find the date on the left-hand side is 28/4/2023.
Page?
Page 15. Left-hand side top.
Yes.
28/4/2023. 2018 ring ceremony took place as the allegation has been placed.
Yes.
My lord, the FIR, then the charge sheet is filed, my lord, and the relevant page is no, relevant page is, my lord, as the charge sheet page 20, where ultimately it was held that last portion, para 16. It is found that the investigation of the case has been completed and found a prima facie evidence sustainable under section 376, 313, 354, 420 IPC, read with 67A of IT Act, and 4 of Dowry Prohibition Act, and such and such. This is the charge sheet, my lord. Then before I proceed to other things, my lord, I take your lordship to one thing. At page 29, your lordship will find page 29. The respondent, page 29. The respondent, the informant, got married on 27/11/24 to somebody else. Thereafter, notices were sent. She did not appear, and an amicus query was provided. Now, I think she is appearing for the respondent number 2. She got married in Malad 27/11/2024. These are the photographs. Malad, before I proceed, there are the sections which had been laid down against the petitioner. If your lordship permits me to place it, Malad. 376. That your lordship is well aware of the recent trend from now that consenting parties both adult. They had promised to marriage. Well, they gave consenting. If it is at all the allegation we take it to be correct, then the 376 does not attract. Then, my lord, I take your lordship to another one because that obscene portion is there. They have said some obscene photographs are there. I take your lordship to page 25. Page 25. This is a report from the Regional Forensic Science Laboratory by the Cyber Forensic Division Scientific Officer. C. As per the query, no obscene photos and videos have been found in the exhibits. So your lordship has got it. Page 25. C.
Yes.
Now, my lord, 376, I will place some judgments. Consenting party, that will be a civil consequence, not criminal liability. 376 does not attract. Obscene, I have given this exhibit. I will place again a Supreme Court judgment. While it says in a 482 or this new provisions, I will give it. Wait. Where this, all, not only the FIR and the complaint, all the things have to be taken, has to be considered. Overall circumstances, along with the other things, can also be from on the basis of a judgment of 2008, 14 SCC page 1. Then it was reiterated in 2013, and the present judgment, I will place that judgment. So another section that has attracted in page 15, your lordship will find in the FIR that the last paragraph, as regards the dowry prohibition, that was the which has they have been stating, my lord, in the FIR last portion. On 16/1/2023, if your lordship was looking at last paragraph.
Yes.
My lord,
Page?
Page 15.
In the FIR itself.
FIR itself, last paragraph. On 16/1/23, the accused came and asked to call my father as well as family members for discussion of social matter. And accordingly, my uncle Shankardev Roy, brother Sandeep Roy, Gopinath Roy, and such came to his house and stated that he would socially marry me and gave demands for dowry. When my family failed to fulfill his demand diary, he refused to marry me socially and such. My lord, here marriage is not required, correct, under Dowry Prohibition Act. But there should be some delivery and there should be, my lord, some acceptance and there. But if only the demand has been said as the allegation and they say that I will not give, that will not attract the dowry. So my lord, 376 goes, my lord, obscene, I have given the documents which I will place on a Supreme Court judgment. My lord, there is no obscene. This Dowry Prohibition Act does not attract. My lord, she got married and she is enjoying her life. She doesn't come to court through an amicus. I, being a sub-inspector of police, my movements order are there and I am suffering. My lord, your lordship, at page 28, your lordship will find that I was given a movement order from one place to another, but it becomes difficult for me to go and attend. So there was an interim order that I will place an application for adjournment. But that does not suffice the issue, my lord. And my lord, if your lordship permits me, I will just start with that Gauhati judgment is on. We are Gauhati. 23. My lord, this judgment I will place, my lord. This is 2023. Judgment, yes, yes, if you are going judgment to it. Yeah, there was judgment আছে তো মোট ফাইলের আছে তো ভাই আরো আছে এই 23 বিআর গাওয়াই my lord, if your lordship permits me, this is Muhammad Wazid. My lord, I will place this judgment, my lord. Para 30, my lord. Before I proceed to other sections, my lord, as regards your lordship is well versed with all this law, my lord, but still then, as to assist the court, I am placing this, my lord. From R.P. Kapoor to Bhajan Lal, then subsequently, this present situation that has come upon me in para 30, your lordship will look into para 30. If I can read slowly, my lord.
Which, this is, which one? Muhammad
Wazid.
Wazid.
Para 30, my lord.
Read between the lines.
My lord,
Read between the lines.
not only lines, my lord, you have to, because it has said that in a 482, my lord, the informant to harass will place everything in a very nicely placed words. That then overall circumstances, everything has to be taken into consideration.
That is what I said, to read between the lines.
My lord.
That is the
in a
exact
shortcut
phrase.
way. My lord, I understand that.
No, in fact, that is the exact phrase used in the judgment. At some place.
My lord, para 30. May I read it slowly, my lord? At this stage, we would like to observe something important. Whenever an accused comes before this court invoking either the inherent power under Section 482 of Code of Criminal Procedure or extraordinary jurisdiction under Article 226 of the Constitution to get the FIR or the criminal proceeding quashed, essential is on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive for wreaking vengeance. Then, in circumstances, the court owes a duty to look into the FIR with care and little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., that he would ensure that the FIR complaint is very well drafted with all necessary pleadings. The complainant would ensure that the averment made in the FIR complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the averment made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceeding, the court owes a duty to look into many other attendant circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection, try to read in between the lines. The court, while exercising its jurisdiction under Section 482 of the CRPC or Article 226 of the Constitution, need not restrict itself only to the stage of a case, but is empowered to take into account the overall circumstances leading to the initiation and registration of the case, as well as the materials collected in course of investigation. Take, for instance, the case in hand, multiple FIRs have been registered over a period of time, such and such. That your lordship is well versed with this paragraph because your lordship has already says, read in between the lines. My lord, the situation is that both of them were reading in the same college. It was true that they had an affair. But my lord, now because this man has a sister, so it was not even possible for him to get married. And now, my lord, whatever is the allegation is that it has come in the affair. Now, my lord, she, after lodging the affair, she got married and went away. But I am suffering. This is my one. Then, my lord, another judgment, judgment to Chandrachuri judgment. Chandrachuri judgment. এটা না 25-26 this is 2003 4 SCC page 46 from paragraph 25 and 26. Para 25 and 26, my lord.
Yes.
My lord, here the paragraph says that ultimately this it appears to happen that the prosecutrix willingly consented to have such sexual intercourse with the appellant with whom she was deeply in love. That was, my lord, from the facts it's stated, because the affair is lost and their relation started in 2018 and the affair is lost in 2023. After 5 years, my lord, the affair has been lost. Then, my lord, the recent judgment of my lord, Madhu Khan, what you want to say that? What I read out there, Madhu. Right. My yes. My lord, this judgment where the Supreme Court has reported in 24 from paragraph 31. Paragraph 31, 32, 35, 36, and 37. Para 31, my lord. Mahesh Damukhare. My lord, if I can read para 31.
Yes.
My lord, I'm reading slowly. In our view, if criminality is to be attached to such prolonged physical relationship at a very belated stage, it can lead to serious consequences. It will open the scope for imputing criminality to such long-term relationship of after turning so. As such, an allegation can be made even at a belated stage to drag a person in the juggernaut of stringent criminal process. There is always a danger of attributing criminal intent to an otherwise disturbed civil relationship, of which court must also be mindful. Next paragraph. It is evident from the large number of cases decided by this court dealing with similar matters as discussed about that there is a worrying trend with consensual relationship going on for prolonged period upon turning so have been brought to be criminalized by invoking criminal jurisprudence. Then para 33, madam. We, however, make it clear that our decision in this case and observation made are to be understood in the factual metrics before this court. Every case must be decided on its own facts and circumstances, for we are dealing with human relationship psychology, which are dynamic and pre-meted with an array of unpredictable human emotions and sensitivity, and hence every decision relating to human relationship must be based on the peculiar facts and circumstances of the case. In light of the aforesaid facts and circumstances, and for the reasons discussed above, we are of the opinion the present case, no prima facie case has been made out about commission of an offense of rape punishable under section 376. Further, on perusal of the FIR, it is also noted there is no allegation of cheating has been made against the appellant to fall within the scope of 420 IPC, nor of any of the offences under section such and such. In our opinion, allowing criminal proceeding against the appellant in the facts and circumstances to continue where no criminal liability can be attached would amount to abuse of the process of court. Therefore, under the circumstances, we are satisfied that the appellant is entitled to relief claim for quashing of the complaint FIR. Consequently, the appeal is allowed, such and such. This is one judgment, my lord. And my lord, then the judgment, my lord, of 2022 by my lord Justice. It is 10, 11, and 14, my lord. My lord, 10 starts with the, my lord, 376, then my lord, 11, one judgment has been referred. Then my lord, para 12, my lord, your lordship will find.
Yes. Para 12.
Para 12. In the present case, the issue in hand, we have addressed the High Court. Allegation in the charge sheet are correct as they stand office principle. Admitted the appeal the single constitutional such and such. The course of the marriage ended in decree, my lord. Then, my lord, taking allegation complaint, it is impossible to find the affair or the charge sheet, the essential ingredients of an offence under Section 376 IPC. The crucial issue which is to be considered whether the allegation indicated that the appellant has given a promise to the second respondent to marry with the inception was false, and on the basis of which the second respondent induced into a sexual relationship. Taking the allegations in the FIR and the charge sheet as they stand, the crucial ingredients of offence under Section 375 IPC are absent. The relationship between the parties are purely of a constitutional nature. The relationship, as noted above, was in existence prior to the marriage of the second respondent, continued subsisting during the term of the marriage, and after the second respondent was granted divorce by mutual consent. So this ingredients is missing, constitutional relationship. No. আরো কিছু আছে নাকি? তো এটাই আর কি। দিয়া দোকানে। কি আছে 85 প্রতিবেদন আনি না দরকার নেই। That is my case, my lord, and I conclude to this effect, my lord. Because she got married and she is enjoying her life. She doesn't appear through her counsel. The amicus query has been given. And taking into consideration, my lord, it was a constitutional relationship for such a long period. If we taking into account that the allegations are correct also. Dowry does not attract, my lord, that obscene, as per the forensic report, nothing has been found. My lord, 376 does not attract, dowry does not attract. That, my lord, the report from the regional forensic says no obscene photos and videos have been found in the exhibits, page 25. So, my lord, ultimately, my lord, if your lordship takes into overall circumstances, sections does not attract at all anything, my lord.
Where did you get these photographs? Were you invited?
My lord, it comes in the Facebook nowadays, my lord. Facebook is such a thing, my lord. Everybody gets everything nowadays. So.
Yes.
My lord, Loksape kindly say, my lord, this is not a case, my lord. This was wherein my lord search is committed under section only 376, my lord. This case has been, my lord, searched under section 313, 354C, 376, 420, reduced section 67 of the IT Act and reduced section 4 of Dowry Prohibition Act, my lord. Now, my lord, Proceed kindly peruse this search sheet, my lord. What are the allegations, my lord? Allegation is that, my lord, there are, my lord, engagement was done, my lord. After that, my lord, she was taken the house of the, my lord, accused person, wherein, my lord, no one was present, my lord, and she was forcefully, my lord, she was forced to, my lord, cohabit with the petitioner, my lord. This is the first incident, my lord. Thereafter, on several occasions, my lord, on blackmailing with the, my lord, stating that, my lord, he is going to marry her, my lord. So he has got the right to, my lord, have physical relationship with her. So he made several times physical relationship, my lord. Thereafter, my lord, if lordship peruse the, my lord, scan copy of the record, my lord. Two witnesses' judicial statement has been recorded, wherein, my lord, they have stated that demand of dowry was met, my lord. One Scorpio vehicle and, my lord, one kotha of land was demanded from the family of the bride, my lord. Now, my lord, as far as, my lord, 420 is concerned, my lord, engagement was done, my lord. Later on, my lord, marriage was not solemnized, my lord. When the family members of the bride, my lord, they pressurized the petitioner, my lord, pressurized this accused person, my lord, to solemnize the marriage. Then he slowly, my lord, tried to, my lord, delay the, my lord, marriage, my lord, by citing, my lord, some ethics, my lord, that not this month, then after some time, after 2 months, then thereby, my lord, he was, my lord, continuing with the physical relationship with the victim, my lord, and he was not willing to marry her, my lord. And secondly, my lord, whatever my learned friend has cited, my lord, this decision has not been furnished to me, my lord. So let me go through the decision, my lord, what he has furnished, my lord. But my lord, whatever the my lord, prayer of the my lord, senior friend, my lord, regarding passing of the search sheet, my lord. These are the my lord, something matter of the trial, my lord. Whether my lord, the case has been, my lord, since the cognizance has been taken, my lord, whether my lord, it is a case of passing or not, my lord, this has to be looked into from the materials available in the my lord, scanned copy of the record, my lord. Because my lord, victim statement is important, my lord. It is a CS stated, my lord, that on several occasions, my lord. It is not that, my lord, their so marriage was not, my lord, finalized, my lord. Their engagement was done, my lord. Thereafter, my lord, the pretext of marriage, my lord. He has, my lord, established physical relationship with her, my lord, and thereafter, my lord, he has refused to marry her, my lord. So, the ingredients of section 420 will come into play or not, my lord. These are all matters of trial, my lord. Now, charge has not yet been framed, my lord, and I have seen, my lord, on 5/5/2025, cognizance taken, my lord. Thereafter, there is no order, my lord. What is the state of the, my lord, proceeding at before the trial court? So, my humble submission, my lord, this is not a case of quashing, my lord. If the trial court decide, my lord, he can place, my lord, all the materials at the time of framing charge also, my lord. If he has a good case, my lord, definitely the trial court will, my lord, discharge him, my lord. But from the materials available in the scanned copy of the record, my lord, there are sufficient materials, my lord. Statement of the two witnesses, my lord, judicial statement of the two witnesses are very important, my lord. That lordship may kindly peruse, my lord, that statement.
Yes.
Lordship, since the senior counsel has taken your lordship straight to page 25, your lordship, that is regarding the FSL report, which the senior counsel has shown that it says that as per query, no obscene photos and videos have been found in the exhibit. However, your lordship, this is just the hard disk. If your lordship turns to the previous pages, your lordship, page 22, your lordship. So this was a mobile phone which was seized, your lordship. Page 22, the first. Your lordship got it? Yes, your lordship. So this was a mobile phone which was seized from the accused. And if your lordship turns to page 23, your lordship will find the first observation, your lordship. Among all the above mentioned extracted data, so-and-so numbers of obscene pornographic images have been found and tagged as important. One chat having conversation with number, so-and-so has been found and tagged as important. And if your lordship sees, this number belongs to the informant, your lordship, the victim. Secondly, your lordship, in the same page 23, there's another mobile which was seized. Your lordship will also find, sorry, your lordship, number 4, the fourth one, your lordship, mobile phone seized. Your lordship got it?
Yes, what are you referring to?
Your lordship, page 24.
Yes.
This was another mobile phone which was seized, your lordship. And if your lordship sees point E,
Yes.
4 numbers of obscene pornographic video have been found and tagged as important. Again, the next it says, one chat having conversation with number so-and-so and so-and-so have been found and tagged as important. And your lordship will again find that this number belongs to the informant, which is already been given in the FIR, your lordship. So your lordship, as per
That's
her
okay. Nobody is denying conversation because admittedly they were in a relationship.
No.
Oh.
Yes, your lordship. So like the learned senior has said that there is no obscene material found on the phones, your lordship. So I just wanted to bring this to your lordship's notice. So does the allegation, is it that absurd, your lordship, that it doesn't make out a case, your lordship? This is what she has said. That he had something on his phone through which he was blackmailing her. And this has already been shown through the FSL report, your lordship. But however, the contents of it, those are matters of trial. But is it so improbable? Are her allegations
Your
baseless?
submission is those obscene videos or photographs may or may not relate to the informant, but
Yes,
that
Your
is a
Lordship.
matter for the trial court to
Yes,
see. We are not going
absolutely, Your
to go
Lordship.
into all that.
Yes, Your Lordship. So because she has already stated in her FIR regarding the obscene materials, Your Lordship. So this FSL report supports that allegation. So can we just throw it aside, Your Lordship, saying that it's baseless? Because these are matters of trial and these contents can only be found out, Your Lordship, during trial. Your Lordship, whether she is living a happy married life or not, Your Lordship, we have nothing to do with that. Nothing bars her from getting married after filing the FIR. And that too, almost about after 2 years, she's gotten married after the FIR. So, Your Lordship, I don't think, Your Lordship, that this is a fit case for quashing.
My lord, to all my friends, brother and sisters reply, only one thing I can place it, my lord. The present situation, what it arrives at now, my lord. After the marriage, she does not engage a counsel. She doesn't come to the court. My lord, a man is proven innocent till he is found guilty, my lord. If they, ultimately it shows that she will never come before the court to face the trial. She doesn't come to the High Court, my lord. She will never come to the trial court to face the trial, my lord. Then if she doesn't come to give the evidence and everything, my lord, what does it stand? Itself, the present situation itself indicates she is not willing to come to the court. He has lost the affair. If he doesn't appear before the court, I am only harassed, my lord, because she is married and she will never come before the court, my lord. The present situation arrives. And after the service is complete, my lord, amicus curiae has to be appointed. That is all my submission is, my lord. And the reason, my lord, for which I have not got married, my lord, the para 4, it is there, my lord. In my petition, para 4, I have given the reason why, my lord.
Yes.
Para 4, I have stated, my lord, because of my sister. After I have told them that I will get married after the marriage of my sister. I have stated in para 4.
Yes.
That is what I am to say. And I conclude, my lord.
Heavy.
Finding item 8.
Wait, please, your lordship. So it's a pre-arrest bail, my lord. Your lordship will find the FIR, my lord, at page 8, my lord. Lordship, may kindly see, my lord, name of the informant, my lord, Sabikun Nehar, and the name of the accused, my lord, Muhammad Siraj Islam, my lord. Respectfully submitted that my husband worked at Dimapur for work. The above accused is a neighbor of our house. I call the above accused as uncle. On last so and so, at around 2 p.m., the accused cut the wall with the door of my house and opened the door hook and entered the house while I was sleeping with my young child. Well, so far the allegation level in the FIR, my lord, it is an attempt, my lord. Now your lordship may kindly have a look, my lord, at page 12, my lord, for a once. Page 12, my lord.
Yes.
Here your lordship will see the informant, my lord, the Sirajul Islam, the accused, my lord. He had filed this, my lord, FIR, my lord. May I read, my lord? It is respectfully submitted that the following accused have been trying to occupy the land of Dag number so and so in the Mosa so-and-so in the name of the complainant's father. Today, 12 to 24 around 8 a.m. while going to think of plowing of the ancestral land in his enjoyment, the accused showed sharp weapons and forcefully occupied 2 kathas of land and threatened to kill the complainant if he entered the road, my lord. Your lordship will see in the, below the address, my lord, number 3, my lord, Sabikun Nehar, my lord. And moreover, my lord, there was another complaint case is pending before the, my lord, court of, my lord, Nagaon, my lord, that your lordship will find at page 17, my lord. 17.
Yes.
Well, this is also a complaint case that is still pending, my lord. So due to, my lord, this land dispute, my lord, this FIR has been filed, my lord. Land dispute is going on, my lord. Well, one FIR, my lord, and one complaint case is still pending before the court below, my lord.
Yes, PP.
The case that we call for, my lord, this is from Thing Police Station.
Some protection, my lord, in thing.
No, it's more than 2 months.
My lord.
You have waited. You can wait for 2 weeks.
My lord. Yes. Some protection, my lord, if your lordship pleases, my lord.
28. 28.
28, my lord, this. I'm obliged.
The arguing counsel is on his legs on some other court.
So,
The matter may be passed over for the time being.
Appeal is against acquittal, my lord. NI case. Required to be
listed for hearing then if everything is complete.
Yes, my lord. Admit it. My lord has to admit it, my lord, and
Third learned counsel for the appellant. Learned counsel for the sole respondent. PCR is received.
no, my lord, it has to
not
be
call for.
called for.
He is admitted. Call for the TCR. Yes, again on. So,
From 2nd of September. From Judicial Magistrate First Class Dibrugarh, man.
yes.
My please, Lordship. Lordship, I am for item number 17, Lordship. In this case, Lordship, I was arrested on 14/2/2026, Lordship. At such, I have been behind the bars for last 5 and 20 days, Lordship. 5 months and 20 days, Lordship. And Lordship, in this case, Lordship, commercial quantity is there, Lordship, but the contrabands, Lordship, have not been seized from my possession, Lordship. Only one thing was seized from my possession, that is my mobile phone, Lordship, and nothing else, Lordship. And Lordship, only on the basis of the statements of the co-accused, Lordship, I was arrested, Lordship. Here in the Lordship, the
Yes,
linkage
PP.
is not also proved, Lordship.
Here, my lord. First, your lordship, they kindly come to the FIR, my lord.
Page.
Page
13.
13, page 13.
Yes. What is the name?
He is, my lord, Rondu Ali.
Rontu Ali.
Yes, my lord. What the gist is that, my lord, what is stated, my lord. First, my lord, some of the narcotic substances were, my lord, recovered from one accused person. Thereafter, it led to the this person Rontu Ali, my lord. After that, my lord, when Rontu Ali was interrogated, he has taken the name
Recovery
of
was made from Rohimuddin.
Rohimuddin. First, it was from Rohimuddin, my lord. Thereafter, it led to the arrest of Rontu Ali, my lord. And Rontu Ali's role is that he led to the discovery of another seizure, that is 860 bottles from one Manik Singh. That is in our next item, my lord.
Yes.
Now, my lord, recovery, my lord, since, my lord, the recovery was made from Manik and it was led by this person, my lord, Rontu Ali, my lord. So he is the
Is there any statement of Rontu Ali in the CD saying that it is there in the, I
Yes.
can lead you there?
Yes, my lord. There in the TCR person, my lord. That as per his statement, he has procured these drugs from the this Manik Singh, my lord, and this led to the my lord, recovery from the Manik Singh after he led to the pharmacy of Manik Singh, my lord. So he is under constructive possession and conscious article, my lord, that was recovered, my lord. So it comes to the next level of, my lord, interpretation, that he was very much aware that my lord, substances are with the Manik Singh, my lord.
The recovery was made, any recovery made at Manik Singh's place?
Yes, my lord, 860 bottles of cough syrup, that is commercial quantity, my lord.
Any documentation?
No documents we could show, do not show documents from, cannot show any documents, my lord.
Lordship,
So, my lord, now, my lord, he is, as per section 30, if we say also, my lord, that he is not recovered, as far, since it is led to the recovery, my lord, as per section 30 of the Evidence Act also, now he is liable, my lord. Section 27, my lord, I'm sorry, my lord.
first of all, Lordship, he was arrested on suspicion, Lordship, and thereafter, Lordship, he was taken.
Not
to
on
the place,
suspicion, on the statement of the co-accused. Not on suspicion.
Investigation will lead in this way, my lord.
Lordship, one thing is clear, Lordship, the commercial contrabands, Lordship, were never and ever, Lordship, seized from the possession of the petitioner, Lordship. Lordship, I would like to rely judgment, Lordship, of our Honorable High Court, Lordship. That is, Lordship, case number, bail application number 1364 of 2024, Lordship, Abdul Kalam alias Hassan, and Lordship, one MD Mustaqim, Lordship, and state versus the state of Assam, Lordship. Lordship, this is a common order, Lordship, bail order, Lordship. Here there are two petitioners, basically two petitioners, two bail applications, Lordship. And in one bail application, Lordship, one hand, Lordship, commercial contrabands were recovered from the petitioner, and in another bail application, Lordship, nothing was recovered from this petitioner, Lordship. Two kinds of bail application here, one common order was passed, Lordship, wherein Honorable High Court observed that, Lordship, though Section 37 of the NDPS Act 1985 provides for intelligent provision for grant of bail, however, Section 36 of subsection 1 of the NDPS Act 1985 also mandates the government to constitute as many as special courts as necessary for the purpose of providing speedy trial of offense under the NDPS Act 1985. If speedy trial is not provided to an incarcerated accused, it will certainly have a negative impact on the rigors of Section 37 of the NDPS 1985. The Supreme Court of India, Mohammed Muslim alias Hussain versus the state of NCT, reported in 2023 SCC Online, so at page 352, has observed that grant of bail on the ground of undue delay in trial cannot be said to be fettered by Section 37 of the NDPS Act 1985, Lordship. So in this case, Lordship, the case has already been charged, Lordship. The trial has yet to be started, Lordship. And already, Lordship, case number also has been allotted to this case, Lordship, the NDPS case number 345, Lordship.
Where is
NDPS
your, which
245 of
judgment? It is not here.
2026. And now, Lordship, the stays the considered as Lordship. Lordship, if this stays, I am not released from the jail, Lordship, then it will, I will get produced, Lordship, because I have to submit, Lordship, at the time of hearing on consideration, Lordship. And Lordship, again, this case, Lordship, at paragraph 19, it was observed by our Honorable High Court, Lordship. Whatever may be the nature of the offense, a prolonged trial, appeal, or revision against an accused or a convict under custody of incarceration would be violative of Article 21. While the
Where
court
is the
will-
question of trial? It is for consideration of charge. Trial is yet to begin.
Now, my lord, here the submission, the learned friend has submitted their judgment. But this judgment, my lord, this does not cover these facts of the case. Now he is harping on, my lord, that long incarceration case. Long incarceration is not an issue at this stage, my lord. Because he was arrested, only one of the forwarding report is of, my lord.
Lordship, the trial is going to be started, Lordship. The next date is, Lordship.
When were you arrested?
Lordship, the stage
Arrested.
hearing, Lordship, 14 to 2026, Lordship.
So,
If we, my
so
lord,
this is the, during this period, investigation has been done, charge sheet has been submitted, stage is fixed for consideration of charge.
Lordship,
So what is the lack of progress in the case?
that is
It's going as per schedule. We would understand if witnesses are not examined for years. There are hundreds of witnesses left to be examined. That is a different issue.
Fine for item number 18, Lordship.
In my case, Lordship, section 37 is no way applicable, Lordship.
All right, we have recorded your submission.
Lordship.
We'll hear all of them first before deciding anything because they are interconnected.
So I am for item number 18, Lordship. And my contention is different, Lordship. Lordship has already passed an order on 29/7/26, but it was wrongly tagged, Lordship.
Different case.
Yes, arising out of same FIR, but my contention was different. And in that regard, Lordship has already passed an order on 6/4/26. And after that, Lordship has passed order on 29/7/26, wherein I have submitted my contention is different. And Lordship has already given a date of 18/8/2026. It was wrongly tagged along with it.
All right, right. This is wrongly tagged. Item number 18. Matter has been wrongly listed today. List the matter again on 18/8/26. So why is it different? It is arising out of the same
It
FIR.
is
isn't
arising
it?
out of same FIR, but if
So
Lordship,
CD will also be the same.
scanty share is also same, madam.
Lordship may once come to order dated 6/4/26, wherein I am the person Manik Singh from whose possession
Yes.
Lordship the
He has a pharmacy, that is why your lordship is perhaps that. Because
and a order was
Order
passed
dated
6/4/26, wherein Lordship has stated the authority may.
indicated that lordship will deal with the matter separate. Because he has a pharmacy, madam, whether his contention will be that, he has to be a license to sell all this, madam. There are some certain conditions, madam.
After that, Lordship charge sheet was filed. We have approached the trial court, and trial court has passed a similar order. So it is awaited for FSL, Lordship, and we will file an additional affidavit in that regard whenever the FSL comes, Lordship.
If the charge sheet has already been submitted, what further FSL report is now required?
Yes.
Lordship, we have, in that regard only, Lordship, I have submitted on last occasion, Lordship, that we will file an additional affidavit, and trial court has considered our petition. And trial court has passed an order directing the authority to specify the percentage after a search. And that, with that regard, we will file an affidavit, Lordship. And the order was passed and it was been given to the authorities, Lordship. Served to the authorities.
FSL, madam, does not bear anything, madam.
FSL report does not indicate anything. Huh?
FSL is pending, madam. Report was not in the.
Oh, charge sheet was submitted without FSL.
after that, but it was the drug, it was tested with the drug detection kit at the time of recovery. It gave positive result.
My case maybe not be tagged with along with 17. Earlier date which was fixed, Lordship, it may be fixed on that.
All right, then list it on 18,
That's
26. Petitioner may file the additional affidavit in the meantime.
Call for up to date TCR may also be called for. Lordship.
If it is submitted there,
Yes, yes.
to call for the up-to-date PCR. And what about these other matters?
Deeply obliged.
that day it was fixed in, that is why it came along with it.
That
Now
is
here, CD is there,
I am for item number 19, Lordship, but I do not understand why these are in series
Those
metal.
cases were
Different.
adjourned at a,
Different,
that is why it was taken. Otherwise, it is not connected.
It is from Sri Bhumi, Lordship.
These are not connected.
No, Lordship.
Only one,
Different,
and 17 and 18 are connected.
Okay, so 17 we will pass orders.
Plus,
17 to হেৰিত দি দিব 17 to চেম্বাৰত দি দিব বাকিখিনি বেলেগ দিব
if the lawsuits wants the regarding item 17, my lord.
হেৰি কালি দেখা নাই কালি আইটেম নম্বৰ কিমান আছিলে Yes, 19.
17, my lord. The lawsuit has indicated that, my lord, regarding to make my regarding the statement of the co-accused.
Yes.
So whether I should make submission in this required or not, my lord, if you're in item 17.
Yes, that issue is there.
That issue already there.
Yes, what is your submission then?
Yes, my lord, the lawsuit has indicated that day, my lord, and that has been in Krishna Mohan Reddy's case, my lord. If, my lord, sum and substance, my lord, your lawsuit has also perhaps gone through, my lord, this sum and substance is that, my lord, if it is, my lord, that a statement is, if it is inculpatory in nature and also implicating himself and also the accused person, my lord, then that statement can be taken into account at the time of, my lord, in the stage of the bail, my lord, if it is very, because, and the judgment that is Indresh Kumar's judgment that I have cited, my lord, that is also be dealt with here, my lord. He stated that if it is by a witness, then it can be taken into account, my lord.
But not by an accused.
Not by an accused, by himself. And also it can be taken if, my lord, that accused, my lord, just I am reading that line, my lord, if it is required, my lord. Not take your losses all the time, my lord, because it will, if we go to discuss, it will take some time, my lord. Losses may kindly take the para 50, my lord. Yeah, I read lots.
Yes.
When where the police statement of an accused person under section 161 of the CRP is neither an admission nor a confession, that is, it is exculpatory in nature and not inculpatory. Such statements can be looked into by the courts only for the limited purpose of ruling out the stance of accused person who are the allegations. An exculpatory police statement of an accused person under section 161 of CRPC, which at the same time implicates another co-accused, cannot be relied upon merely because such statement is not hit by the safeguards and rigors that apply in respect of inculpatory statements in the form of admission or confession. Well, just the next line, my lord, I feel it is important, my lord. The fundamental canon of criminal jurisprudence is that a statement of one accused person cannot be used against another co-accused person. A limited exception to this aforesaid general principle are inculpatory confessions, where the accused person in his confessional statement not only admits his own guilt but also implicates another co-accused. The rationale behind this limited exception, as explained in Bhavani Sahu, is that an admission by an accused person of his own guilt affords some sort of credibility or sanction in support of the truth of his confession against others as well as himself. The point I want to stress, my lord.
This is where
In paragraph 50, my lord.
50.
50.
Oh, but all right, but the findings have been summarized in
Summarized
53.
in paragraph 53, my lord.
Yes. If you go to 5, Roman 5.
Yes, ma'am.
So here we are concerned with that only, a confessional statement
Yes.
implicating another co-accused
Another co-accused, madam.
can be taken into consideration by the court against such co-accused in terms of section 30 only at the stage of trial.
Trial. Confession itself was relevant and admissible in terms of evidence.
All right, we are not concerned with that, but it
And
says
yes.
only at the time of trial.
And also, my lord, another your lordship will kindly come to 9, my lord. Roman 9, my lord.
Yes.
Although a handful of
So
decisions.
Indresh Kumar has been.
Yes, referred to, my lord.
But this is only with regard to witnesses, not accused.
Was witnesses and courts at a state of regular purpose of ascertaining whether a prima facie case or not, my lord. That is regarding the witnesses, my lord.
So what you had cited was Indresh Kumar.
Indresh Kumar, my lord.
So that has been taken care of
Yes,
already.
that is been taken care of here, witnesses. Now here is the case is slightly different because it led to the recovery.
That is what we are trying to, we'll have to.
Yes, because here it is here hit by my lord section 27, my lord. And also, my lord, here since it's a special act, my lord, the interpretation will be, my lord, whether it is conscious and constructive. Two parts are there, my lord. He is in the, my lord, in the constructive position of those. Because there are decisions plus this. If required, my lord, I can give more, my lord.
Who, item 17, that fellow is in constructive position of what?
That which was recovered from the pharmacy.
Oh, once he hands over possession, how can he be in constructive position? He took it from this pharmacy, then delivered it to another person.
Implied
Was no longer in possession at the time of recovery.
No, it is in the position of that person, my lord, which is knows it, my lord. That comes in section 27 if your lordships in evidence act, my lord.
No, section 27, it
Yes.
is limited to discovery of a fact pursuant to disclosure made by the accused.
Yes, that is there.
So
And
he has
also-
made a disclosure that
Yes,
such and
yes,
such thing is
vis-a-vis,
there.
my lord, that was discussed in a decision, my lord. Regarding
He has disclosed, and upon his disclosure, they went and found
Yes,
that recovered the.
if he is aware that that thing is with that person, my lord, then that led to the recovery, then, my lord.
We are only on the question of admissibility of his statement.
Yes.
So if his statement is admissible under section 27, then that can be used for deciding the bail application. That is the only thing.
That is all. And also, my lord, regarding NDPS, my lord, if he is in possession, if he has knowledge of the fact, that is also a, my lord, a relevant factor that is discussed in some of the decisions, my lord. The lordships require, my lord, I can submit.
Yes, you can submit, no problem.
If your lordship give me 1 day time, then I can submit tomorrow morning, my lord.
All right. 17 of 17 of proceeding.
Please, your lordship. Item 19, lordship.
Yes.
In this case, lordship, the two petitioner, lordship, and driver and handyman of a lordship, Blue Dart Express Limited, and the lordship courier service lordship, and Assam Rhino Express lordship. And on the date of lordship, and on the date of 18/4/2026, one Naka checking was placed by the police lordship after getting the secret information. So lordship, and some calf syrup has been recovered from the container lordship. And apart from that lordship, the vehicle is from the courier service lordship, and they are the engaged driver and handyman helper lordship of the container. And whatever lordship and loaded lordship, that is the other person lordship and distributor, and all the items is seal packed lordship. And even then lordship, the driver and handyman are not allowed to lordship view the item, that because there is the other person is there lordship, and laborer lordship, they have loaded the article lordship. So my lord, and in this case, lordship, the FIR lordship is very clear, lordship. They are the only their role is only drive the operation, the vehicle, operate the vehicle, lordship. So my lord, the something has been recovered that is kept in a concealed position of lordship and cartoon, lordship, that is by wooden cartoon and with seal packed, lordship. And where is the barcode is there and something else, lordship, that is by the courier service, lordship. So, my lord, and subsequently, lordship, they have been arrested on purely suspicious ground, lordship. Nothing has been, they were bodily charged, lordship, but nothing has been recovered from their possession, lordship. But whatever recovered, lordship, from the container, that is the other person, lordship, and distributor is there and supposed to destination, lordship. So, apart from that, lordship, the section 47 and 48, 48, lordship, I am coming, lordship, that point, lordship. And
3,600 bottles were recovered.
Recovered.
And
from
you
the-
were saying they're courier.
there are, lordship, the
In the-
one-line items and
Yes,
lordship
blue dart
message.
items are there. Blue dart items are there, but along with that, madam, there
Yes,
is
yes.
other cartoons also. madam.
These are,
Is the
lordship,
technique.
The technique, madam.
so, my lord, that is not the part of a driver and handyman, lordship. The courier service, lordship, they have loaded under their possession, under their control, lordship. But driver and handyman are not the possession and they are not the control of them, lordship. So, section 8 is very clear.
So is there any seal and cover of this
No.
courier agency on the that cartoon
Yes.
from where it was recovered?
Wooden cartoon, lordship.
The blue dart item that are sealed, madam. But these are separate, madam.
These are separate.
So, my lord, and another, lordship, and the law
They are
point.
very much aware, madam.
The section 48, lordship, and 47 is compliant, lordship, that is at the time of arrest, lordship, and I have filed the additional affidavit, lordship. I'll take it, lordship.
Yes, what is the submission with regard to that?
Lordship, and the 48, lordship, is not communicated to the any person, lordship, of the petitioner, lordship, any relative or either, lordship, and I have annexed, lordship, the additional affidavit, lordship. I'll take page number 109, lordship. Additional affidavit. 109. And the background of the case, lordship, the part of the FIR, lordship, that is quoted, and subsequently, lordship, onward, lordship, page number 110, 1110, lordship, 110, lordship. There is nothing, lordship, and the section 48 is communicated with the person is there. Whatever is recovered from the container, lordship, that is up to control by the courier service. And they are the registered courier service, lordship, Blue Dart, and very reputed. And then another is Assam Rhino Courier, lordship, Express Limited. And the vehicle is loaded by the container laborer at Goripur. Very clear, lordship. Their role is, lordship, there is nothing, lordship.
Any what about 48?
47 is there, 48 just I'm.
That's another thing, lordship, and the lordship, page number 17 for a moment, lordship, is the second para, lordship.
Page?
17, 17, lordship, original petition. Second para, lordship. May I read in middle, lordship?
Yes.
After receiving the authority letter, so-and-so, lordship, and separate notice you are served to the person by me, as per the provision section 50 of the NDPS Act, in presence of the independent witnesses, whether they wanted to charge, to be charged, and in presence of the gazetted officer or the magistrate. However, they could not be taken near to the magistrate or gazetted officer, and I feel that they might part away with any suspected drugs and which was suspected to be in their possession. And I myself charged the person according to section so-and-so, so-and-so. And so they have even then not gazetted officer, even then they were not charged by before the magistrate also. And even then the petitioner was demanded.
Say.
I'm forwarding the ones, forwarding ones, order lordship and passed by the honorable court lordship.
There's 48.
It is stated that 48 is supplied, but is not the part of the CD. Well, I'll cross check and say, my lord,
I have collected
like-
certified copy lordship
only
from the original
regarding
record.
that. I will-
And this is the lordship and the courier service lordship and driver and handyman lordship. They have no any role lordship and apparently lordship.
Sometimes, my lord, it is that my lord, the trailer is, my lord, locked, my lord. They were not given as a lock and seal, and they were not assessed to that items, my lord. In that case, some observations were made by the honorable court, but not in all cases where the drivers are taken access to the products, my lord.
48, we have not found anything.
That's 48 even.
You have not found any
Yes, sir.
proof of service.
Yes, proof of service.
That is the CD you have.
CDs have, CDs, yeah.
So if you can't find it in the CD, it's nowhere else.
Just I am checking whether I have skipped notice or not.
All right, you check up,
That-
no
that-
problem.
That is my. Just
All right.
only that much. Otherwise, my lord, his implications are there, my lord. They recovered from conscious possession.
Here lordship and container is lordship, their lordship. Published lordship. Sign off.
That's a matter 30. Publisher verify code or something. Or it is 17 or 20. 20. 20.
20 years.
Yes, Lord. 20 Lord. What's it now? How are you saying? 27 days. 27 days. The 21B lordship. Intermediate quantity lordship. Or 18-year-old boy lordship. Nothing has been found on his position lordship.
Is the affair?
His cousin brother asked him to come with him lordship. Lordship, everything was found, nor his car lordship, nor from his position lordship. He just went with his cousin brother, only fault that he went with his cousin brother lordship. Just 1 kilometer away from his home lordship.
একত কোন আহিছিল?
So the recovery was made from Mustaqim Ali.
Yes, Lordship.
Again,
And this petitioner was in the motorcycle. Escort.
escorting, my lord.
How many days now?
27 days, Lordship.
About section 50, any notice is there? Properly conducted, any notice? At all.
Sorry, my lord.
But you check, we'll
Lordship,
rise for 5 minutes.
Lordship. The search, my lord. Section 50 legal rights, after explaining the legal rights under section 50 of the NDPS Act to the suspects, my lord. The section 50 observations was made and he was told that he was regarding the legal rights under section 50, my lord. But he had,
Then
my lord, other things I am not found, my lord.
whether he said yes, no, magistrate, anything is there, nothing. Then counsel for the petitioner and learned additional PP. There is an application under so and so the petitioner along with two others, I think, no? Or three others were arrested on 9/7/2026 and an intermediate quantity of suspected drugs was recovered from one of the co-accused. The petitioner was riding a motorcycle escorting the other four-wheeler vehicle in which the remaining accused were traveling. Full stop. Para, it is submitted that nothing was recovered from the possession of the present petitioner. Full stop. Learned additional PP submits that the petitioner was part of the team and was acting as an escort. Perusal of the CD indicates that the actual recovery was made from the possession of another co-accused. What was his name?
Is my lord Mustaqim
Mustaqim.
Ali, no?
Mustaqim Ali. So moreover, perusal, although it is stated that body search of the petitioner was made, comma, there does not appear to be sufficient, appear to be any document to show that there has been compliance with section 50 of the NDPS Act relating to personnel search, comma, which is mandatory.
Thing has been found from him. now.
Having regard to the above. And also considering the period of detention of about 27 days.
Yes, Lordship.
Prayer for bail is allowed. 50,000 to securities. Section of
Is in Kamrup, Lordship.
publish. The conditions of something.
Here CD is not received, my lord. Lordship, only fix a date, my lord.
Receive list again on
None appears, my lord.
none appears. CD
2-0, my lord.
CD received.
It's a such case, my lord. Item 24.
After some-
Intermediate quantity, one witness examined.
After something.
Lordship. Instruction, Lordship, I have to file written objection.
What about CD?
Is there a signal?
Right. CD received. Learned counsel enters appearance for respondent number 2 and prays for. You appear earlier date also.
That time, instruction was not received, Lordship.
Instructions, Lordship,
Yeah,
whatever
gang
they
rape-
decide, submit orally, Lordship, whatever they want. He's a 19-year-old boy, Lordship, almost since 1906, he is in judicial custody, Lordship.
Victim girl become unconscious and on gang rape, continuously upon the her with 3 culprits. Lordship. Next Monday, Lordship. File tomorrow.
All right, learned counsel, Mr. R.A. Ahmed submits that instructions have been received from the respondent number 2 and prays for some time to file a written objection. Accordingly, list the matter again on Monday. Okay.
Like,
26 to 28.
All different cases, my lord. But the petitioner is same.
All different CDs then.
Yes, my lord.
Three different police station
Madam.
case number.
Page 11 is the FIR, my lord, in 26. Here, the petitioner is not named, my lord. One Tausik is named. Tausik Hawk. It ordered, no?
Yes.
And Lord, you may kindly, my lord, page 45, my lord. The Tausik Hawk, my lord. He has been granted pre-arrest bail by the learned additional session judge Dibrugarh, my lord. And page 48, my lord, is the driver and the and other accused person on page 48, my lord. They've been also granted bail by the learned court at Dibrugarh, my lord.
Page?
My lord, page 48 is the order of the other accused person, my lord. by the learned court at Dibrugarh.
The delayed production.
On page 51, my lord, as Tosi was granted bail, that's why page 51, it is reflected, my lord.
One is part of the order.
Yes, my lord, but Tosi Hawk name is reflected there. So, my lord, that what Lordship might remember, my lord, few days back, my lord, Lordship has granted some bail, my lord, one person there is Abdul Mintu Ali, who is the main accused in that case, my lord. Of a case, my lord, there are a series of cases, my lord.
Yes, the firing incident.
Yes, my lord. That firing case, my lord. Now, my here, my lord, Lordship might remember his wife also was suffering from cancer, my lord. And Lordship, the orders also reflect his wife's order, my lord. Babulda. Paragraph, my lord.
Yeah, that wife was granted bail.
Yes, but and other family members was granted bail, but in different case, not in these cases, my lord. Not in these cases, but wife, my lord, suffering from cancer, no one to look after her, my lord, except two minor children are there, my lord. In Lordship's order, paragraph 6, my lord, reflects, my lord. And here, my lord, actually, whatever, my lord, in the actually, my lord, there are cases pending against him, my lord. He got interim in one case. He went to the police station, and police arrested him in series of cases, my lord. That interim order is at page 41 in my lord, series of cases, my lord. Page 41, my lord, he was granted interim bail when considering his wife's illness, my lord. Then he was arrested in these cases, my lord. And already the person who was named in the affair in the cattle case, my lord, he has been granted pre-arrest bail. The persons who were arrested in the cattle case, they were also granted bail. Considering his wife's illness, my lord, and knowing that he was in custody.
So what about other cases? Suppose we grant you in this case.
Even other cases are I'm coming, my lord, one by one. There are other cases, my lord. And there are other cases also, my lord.
Yes, maybe.
My lord, in this case, my lord, although my lord, he has not been named in the affair, my lord, but my investigating officer has collected sufficient materials, my lord. He is also one of the associates of the main affair name accused person, my lord. And Lordship, for a moment, my lord, Lordship may kindly peruse, my lord, page number 36 of the bail application, my lord.
Yes.
These cases were registered from the year 2017 itself, my lord. Starting from Gauhati, murder, my lord. Then, my lord, cheating, my lord, theft, my lord. And, my lord, lastly, my lord, the Borbura PS case number, my lord. Sir, my lord, all registered, my lord. The Assam Cattle Preservation Act, my lord. My lord, my humble submission, my lord, at least as I am opposing, my lord. Since, my lord, the investigation is pending, my lord, other accused persons are yet to be apprehended, my lord.
Okay, what about the next case?
Yes, my lord.
My lord, next case, my lord, my lord, it was a clash between two family members, two families, my lord. When blaming each other, my lord. Though Arms Act is there, my lord. But, my lord, the lordship may kindly see the case diary.
You should be kept away for about 5 years at least. You will not reform.
My lord,
Every
there
time
was
you
no
come out, you will create some more trouble.
No, my lord. Actually, if there are cases again, and other cases are between these two families, my lord. Only this cattle act was cattle case was the other cases between these two families. The petitioner's family and the informant's family. No arms, nothing was used, my lord. All cooked FIR, my lord. No injury also, nothing, my lord, in this case, possibly. And in some of the cases, man, I've been acquitted also, my lord. In this case, my lord, whenever I was granted interim, I went to the police station. Then this case was registered. After, my lord, interim was granted, my lord, by the same families, my lord. There is a history of, my lord, these two families, my lord, they fight among themselves. Lordship, may kindly see the FIR, my lord. It was 2/7. The FIR date is 2/7, and I was granted interim bail on 30. That is at phase 40. Intermediate attended. Page 33 is my interim order. I was granted interim bail on 30/6/2026, and this FIR, my lord, was lodged on, my lord, after that, my lord. 2/7. When I went there for recording my statement, I was arrested in this case. Two-seven, my lord.
Yes, PP.
In this case, my lord, this accused person, my lord, Mintu Ali, my lord, he allegedly sought one Abid Ali, my lord, who is the brother of the informant, my lord. The case that reveals, my lord, the injury report is yet to collect, my lord. But the two of the victim statements are yet to be recorded, my lord, because due to some, my lord, unavoidable circumstances, they could not appear before the judicial magistrate to record their statement, my lord. So I have strong objection in this case, my lord, because the witnesses have also, my lord, educed stated before the IO that, my lord, he sought one Abid Ali, my lord. It's clear from the, my lord, case. Abid Ali, who is the brother of the informant, Ijaz Ahmed, my lord.
He implicated.
Yes, my lord. But my injury report.
But here informant is Jasmine Begum, my lord. Informant Jasmine Begum.
My lord, I am reading from the, my lord.
Injury report is not available, then it's difficult.
But actually, false case, my lord. Whenever, as soon as I got interim bail from this court, I went to the police station. This affair was lost, my lord.
And thereafter, my lord, he started threatening the family members of the, my lord, informant, my lord, to withdraw the case, my lord, and showing, my lord, guns. So let this, my lord, up-to-date case diary be called for, my lord.
What is the date of arrest?
On he said. Huh? 3/7, my lord. And I went to the police station, my lord, recording my statement. I was arrested, my lord. They lost the case, my lord. Where from this affair came, my lord, we don't know, my lord.
Sir, how soon?
Hello.
When can you get? Because it's already 30 days.
30 days, madam, that will be, no, next week, madam.
But
Alright,
for
next
33 days. And the 28 also, same type of FIR, my lord. Same allegation, only to keep me in custody, my lord. And that too in a, this FIR was lodged in 2025.
Next Tuesday. Next Tuesday.
Yeah, my lord, that will be on 13, my lord. 13, my lord. We'll retain the case there, my lord. We'll try to obtain the
My
injury
my
report.
lord, on 11, my lord, his other case is pending, my lord. Can it be on 11?
11.
11.
11 is next Tuesday, my lord.
If the other case is there, let it be on 7th itself.
Okay, my lord.
Only injury report is required.
Only injury report in both the cases, my lord.
Okay, item number 18, sorry, 27 and 28. Additional PP submits that although the CD is available, injury report is not. Hence, the matter again on 11. 8, along with,
That I forward, my lord. One of the things.
all right, 7.
On 11, my lord.
CD be retained, learned, we obtain the jury report. Then the 7 and 28, right? 26 we have heard, I think, yes.
Yes, Lord Lordship. 26, there is nothing, my lord. The main accused has been granted pre-arrest bail. The other persons has been granted bail.
It is
26
disposing
we'll
of
see in chamber.
11 fixed court.
on all the 3 cases, ma'am.
26 is different case, my lord. The cattle case, my lord.
26 will dispose.
Dispose of them.
Oblige, my lord.
I am 52 days in custody, Lordship. And I have an instruction, Lordship. 2 FIR named accused Mir Hussain and Akram Ali already enlarged on bail. Lordship, I am not named in the FIR, Lordship. May kindly have a look into the FIR, Lordship. This is a case where this one boy went missing from the train which was moving towards Bangalore. On the last occasion, Lordship, I was submitting regarding delay presentation before the court, but today I am on the length of detention, Lordship. Already 52 days I am in custody. And FIR named accused has already been enlarged on bail, Lordship.
Why can't you get the order?
It is difficult in my part, Lordship. May kindly see.
Nowadays, what is the difficulty?
So this IO has paid for some time, my lord, to produce the case there, ma'am.
This is the second time, Lordship. Second time the CD has not been produced. I would pray, Lordship, considering my length of detention, I should be enlarged on bail on any condition, Lordship. I am not an FIR named accused also. If your Lordship looks into the forwarding, Lordship, there are 5 accused person. Out of these 5 accused person,
What is your name?
my name, Lordship, there is 2 persons, Pintu Biswas and Vinay Kumar Sharma. And one order I am having, I can share with your Lordship. The order actually. One Tafiqul Haq has also been released on bail. That order I am having that I can share with your Lordship.
Yes.
Lordship, may kindly have a look. So far, Mir Hussain and Akram Ali is concerned, I am sorry, Lordship, I am not having their order. They have also been released on bail.
Learned counsel for the petitioner, learned additional PP. This is an application under so and so. The CD as called for has not been received. NIO has spent further time. The allegation against the allegation as reflected in the FIR is that the younger brother of the informant was approached by the two FIR named accused persons, Mir Hussain and Akram Ali, on the pretext of taking him to work. And thereafter they took him towards Rongia station, and since then he has been staying. Full stop. The accused persons were arrested along with 3 other accused persons produced before the magistrate.
We were taken into police custody also, Lordship, for 2 days.
On when? And were taken into custody on?
On 14 itself, Lordship, after my arrest, Lordship.
On 14/6/2026.
Requirement for police remand and reasons thereof, page number 19, Lordship. Seven days they prayed, but 2 days was allowed. That is my instruction.
2 days of police remand was granted, whereafter the petitioners were remanded to judicial custody. In the meantime, they have spent 52 days behind bars. Further, co-accused of the case, Mohammad Tawfiq Haq alias Kalu, has also been granted bail by the learned additional session judge Kamrup Rongia by order dated 14/7/26, certified copy of which has been placed before the court. Having regard to the above, prayer for bail is allowed. 2 sureties. Satisfaction of additional session judge Kamrup Rongia.
I am diplomatist, Lordship.
My submission may be recorded.
You say PP has served for time as, that is your submission.
The case diary and objection for bail without the case diary.
Section you did not make, you said CD price for
The case
time.
diary is not before us, man. That is why. There are
Learned additional PP. There we have stated nas, IO has paid for learned additional PP. The CD.
Diplomatist, Lordship. Please, your Lordship. Kenzari was not
not the same money.
before Paltan Bazaar. Can it be on Friday, my lord?
So Monday, man.
All right, CD not received, please taken on Monday.
My lord, can it be on Friday, my lord? Friday, my lord. From Paltan Bazaar itself, my lord. We'll try, man.
All right, Friday.
Diplomatist.
Please, your Lordship. Lordship, can you taken on 2 p.m.?
Item 19, the Lordship is asking paid notice, my lord. There are 2 petitioners. Out of that, one I have found, my lord. But in the forwarding, it is stated that both were served with a 48 notice, my lord. So that day after tomorrow, at least I will take some. that much.
All right, day after tomorrow.
Because
Please
one is
matter.
getting, otherwise, yeah.
So and so in order to enable BP to obtain further instructions regarding service of notice under section 48 BNSS.
And deeply obliged.
It may be written lordship.
CDB written.
Obliged.
May I please, Your Honor? Your Honor, my item number is 42. But it's some
Petition is dismissed. Yes.
Please, Your Honor, Lordship, my some medical emergency, I need to go home. My item number is 42.
Yes.
And please kindly adjourn the matter.
All right.
Much obliged.
Friday.
Next week. Next week, any date?
It is here, we can have it on Friday.
Friday?
Okay, today is emergency. Sunday.
May I please, my lord? This is an application under 528 on the BNSS. My lord, the case pertains to this particular application is that, my lord, the present petitioner, he has been convicted by the trial court. Thereafter, appellate court has upheld his conviction and aggrieved by the concurrent finding, he approached the High Court. And thereafter, my lord, revision petition that has been filed before the High Court, that has also been rejected. Now, I would
Revision is also rejected.
revision petition is also rejected, my lord. But one incident has happened, my lord. While pendency of the revision petition, my lord may kindly come to page number 35. My lord, this particular revision petition was subject to deposition of 1,50,000 amount that has been paid to the respondent. That means the complainant of the complaint case. Now the total amount the check was involved, my lord, is 2,50,000. Thereafter, trial court has directed the accused person to pay 5 lakhs rupees. So during the time of the revision petition, he has already paid 1,50,000, and my lord may also come to another money receipt that is on page number 35, my lord. This particular money receipt reflected that he has received another 99,000 rupees. The complainant has received another 99,000 rupees. Thereafter, my lord.
What was the total amount?
Total amount, my lord, total amount paid to the complainant is 6,99,000. But there is one aspect, my lord, so far as this 99,000 is concerned, that particular money receipt has not been exhibited. So I am excluding that amount. Even if we exclude amount of rupees 99,000, he still received 1,50,000 plus 4,50,000. That means the amounts come around 6,50,000 rupees.
Out of?
Now,
out of?
My lord, total check amount is 5 lakh. Total check amount is 2,50,000. Then the honorable court directed him to pay 5 lakhs. But in total, we have paid, your honor can assume that we have paid 6,50,000. That is on record, my lord.
Why have you become so generous later on?
No, my lord, I have to become generous because I have to go behind the bar, my lord. So, after the revision petition was rejected, my lord, a subsequent development takes place. And that subsequent development I have brought by way of a joint affidavit, my lord.
During the pendency of the revision, you deposited the amount, certain amounts.
Certain amount, my lord.
Then you got it dismissed after getting the money. Yes.
My lord, this particular settlement it clearly reveals that the complainant has received 4,50,000 as a full and final settlement. My lord, may kindly come to page 58. I am referring to paragraph Z and H. That this particular amount should be considered as a full and final settlement, and the complainant would not bear any grudge after receipt of this particular amount.
So now tell us, after the coordinate bench or
Yes, my lord.
High Court has single judge of the High Court has dismissed the revision, can once again invoke
Yes, my lord.
his power.
Now, my lord, the inherent power can be exercised on arisal of the fresh cause of action. If that particular cause of action is enforceable under the statute itself, my lord, then my subsequent 528 petition is maintainable. Because there is a
Enforceable under
specific-
the statute means?
My lord, there is a specific provision under Negotiable Instrument Act. I'm
Yeah.
referring to section 147, my lord. 147 read as notwithstanding anything contained in the Code of Criminal Procedure Code 1973, every offense punishable under this act shall be compoundable. That means this particular provision is going to have an overriding effect over the CRPC. So whatever the procedure that has been described in the CRPC is not applicable.
But how is
And-
that aspect not considered by the revisional court?
My lord, revisional court, why? Because at that time I was not engaged in this matter, my lord. Subsequently, when the settlement took place, I have engaged in this matter.
Where is the order of the revisional court?
My
Revisional order, revision court's order.
Revisional court order, my lord, will find at page. My lord may kindly come to page number 24. And my lord will find the operative part at page 30, para number 16. Considering the aspects, considering the facts and circumstances of this case, I do not find any legality, irregularity committed by the court of learned additional session judge so and so in appeal case number so and so, affirming the judgment and order dated 15/10/2013 passed by the court of learned chief judicial magistrate in connection with so and so case. But my lord, in order to sustain my petition, I would like to.
This was purely a decision on merits.
Yes, my lord.
And there was nothing wrong with the impugned
There is
order.
nothing wrong, my lord. We do not have any grievance against the judgment that is passed by the revisional court.
Yes, what do you want to rely on now?
And my lord, there are two judgments. One is passed by the Honorable Bombay High Court and another one is passed by the Honorable Supreme Court. Yes. Yeah, if I I'm relying on the judgment of the Bombay High Court because this is the latest one and this particular judgment has been passed on 20th April 2026. My lord will find at page 3, para number 6, the factual position in this particular case is exactly similar to what we are dealing with right now. Para number 6, my lord, being aggrieved and dissatisfied with the same, the appeal and the applicant preferred an appeal bearing a criminal appeal so and so. The said appeal came to be dismissed by the judgment and order dated 5/7/2022 against the same present applicant preferred criminal revision petition application so and so, which was dismissed by this court by judgment and order dated 18/11/2024. Thereafter, my lord may kindly come to page 7. Page 7, para number 17. The Division Bench of Himachal Pradesh High Court has taken into consideration Setinan of judgment and observed in para 21 that the Honorable Supreme Court has time and again reiterated the compounding of offense under 138 of the Negotiable Instrument Act. Through section 147 of the NI can be given effect to even at the later stage of the proceeding, subject to the parties agreeing to an appropriate compensation. Further, taking into consideration of the object of section 138 and 147 of the NI Act, there cannot be any reason to refuse to record a compromise entered into between parties to compromise the offense under Section 130 of the NI Act. The offense under Section 138 of the NI Act is a civil wrong. The said offense is primarily concerned with the private parties, and therefore such offense cannot be treated at par with other criminal offenses. And finally, what is the observation exclusively by the Honorable Bombay High Court that is reflected at page 9, para number 23, my lord. Page 9, para number 23. This is the ratio that has been decided by the Bombay High Court.
Yes. Anything to say? All right, I'll pass on this.
Deeply obliged, my lord. Good with it.
Fair physiology. My lord, POSCO, my lord. 7-year offense. Yes, my lord. My lord, 7-year period offense, my lord. First is, my lord, with all respect, my lord, 35(3) notice is a must, my lord. And that was not served. And apart from that, my lord, the time schedule has been given for, my lord, taking evidence. That is also, my lord, contrary to, my lord, in consonance with, my lord, section 346 of the BNS says, but there is a specific section in the POSCO Act, my lord, 35(2), my lord, overriding the effects of 35(2) under the guise of 346, everyday witness taking has been provided, my lord. To that effect, a revision application is pending. May I come to the FIR, my lord? Lordship would kindly have a look at page 19. These are allegations, my lord. My lord, our case is, my lord, fight between the headmaster and his assistant, my lord, teacher, and hence the case. And allegations are 1.5 years back, my lord, 19. And the case has been searched, my lord, with all respect, my lord, within 12 days, my lord. And now, my lord, yesterday 2 witnesses were examined, and today 3 witnesses have already been examined. And, my lord, the time schedule is at, my lord, page 33. 133. Oh, I'm sorry, my lord. Time schedule has been given, my lord. Page 36, my lord. Page 36, my lord. On 3/8/26, then 4/8/26, on 5/8/26, on 6/8/26, on 7/8/26. The victim has been examined on 3rd. That is in accordance with law, my lord. Can I come to the law, my lord, with all respect, my lord? That occurs at my lord, article, my lord, section 35(1) of the POSCO. Period for recording evidence of sale and disposal of quiz. The evidence of the sale shall be recorded in a period of 30 days of the special court taking cognizance of the offense. It is exactly in time, my lord. It has to be within 1 month, my lord. And thereafter, how trial has to proceed, that is at 35(2), my lord. The special court shall complete the trial as far as possible within a period of 1 year from the date of taking cognizance of the offense. 1 year, my lord. Now, my lord, here, this has been carried out every day. 3rd, it was carried out. 4th, today it has been carried out. 2 witnesses examined. Next dates are 5, 6, and 7, my lord. Without his instruction, those are being carried out. And now, my lord, the order has been passed, page 36 at the top, my lord. Invokes its power under section 346 BNSS. 346 relates to, my lord, offenses other than POSCO, because POSCO is specifically provided under section 35(2), the trial has to be completed within 1 year. Now, my lord, 346 relates to, my lord, with all respect, in every inquiry or trial, and proceedings shall be continued from a day-to-day basis until of all the witnesses in attendance have been examined. And the sections of law are provided, my lord, whatever be it, my lord, everyday basis, my lord. But this is contrary to what has been provided to in 35(2), my lord. The trial has to be completed within 1 year. I have been prejudiced because the reason, my lord, because 35(2) would be applicable. He cannot invoke the jurisdiction of 346, my lord, because specific provisions in a specific act, and the act is POSCO, my lord. Section attributed is POSCO, my lord. Section attributed are of the POSCO Act, my lord, and all 7-year period offences, my lord. Hence, we are seeking bail, my lord. Otherwise, without his instruction, trial would be complete, my lord. And the revision application has been kept pending only because the reason, my lord, notices could not reach, my lord. Without notices reaching, my lord, with all respect, my lord, even amicus could not have been provided, my lord. With all respect, my lord.
If revision in respect of that question is pending, we
Yeah.
cannot decide that here.
No, I'm not saying, no, my lord. Definitely not, my lord. That was not my prayer, my lord. What I was saying, that he will be highly prejudiced if he stays inside, my lord, because tomorrow also witnesses would be taken also, my lord. He being inside, my lord. And apparently, my lord, the occurrence is 1.5 years back. Now, may be propped up, may not be propped up. That's a different story, my lord. 48 days in custody, 60-day period offense, had it not been charged sheeted, my lord. And forwarding is, my lord, I can read it, my lord, with all respect, my lord. And that
No, if it is to be completed in 1 year from date of evidence, how much time has gone?
Hello? 12 days, within 12 days, charge sheet has been submitted, my lord. And it has been fixed on a day-to-day basis. 3/8, today is 4/8, my lord, 2 witnesses taken. The next dates are, my lord, subsequent dates are, my lord, 5, 6, and 7, my lord. That is, my lord, within a month, my lord. And on the 10th, my lord. 35(2), my lord. Child witness has to be examined within, my lord, with all respect, my lord, 1 month of taking cognizance. That has been rightly done, my lord, on 3/8. Mother and the child, my lord. Vital witnesses already examined, my lord. Here 35(2) would be applicable, not that, my lord, tenor of 346, my lord. And it has been invoked, power, my lord, every day, my lord, hearing under section 346 of the BNSS. 346 should not be at play, my lord. It would be 35(2) should be at play, my lord.
As far as possible.
Exactly, my lord. But, my lord, POSCO will prevail, my lord. Honestly,
Yes.
my lord.
POCSO says as far as possible.
My lord.
Then-
Outer the date has been given, my lord. So, my lord, heavens will not fall, my lord, with all respect, my lord.
No, heavens will not fall if it is not concluded within 1 year. That means it's as far as
Either way, my
possible.
lord, lordship is also correct, my lord.
Special court shall complete the trial as far as possible.
Exactly, my lord. So, meaning, but not at first, my lord, to that effect also the authorities are there, my lord. With all respect, my lord, it should not be detrimental to the accused, my lord.
So when was the cognizance taken?
Cognizance taken exactly, my lord. 1 month prior, I am giving it. 14/7, my lord.
26.
My lord.
Yes,
26.
Yes, 12 days, within 12 days, charge sheet has been submitted, my lord.
Yes, 31.
The data are correct, my lord. On 3rd, the lady has to be examined, my lord.
All right, that has also been done. So if
Yes,
it is taken in 14/7/26, we have till 14/7/27 to complete the trial.
The first is correct, my lord. The lady examining on 3rd.
No. You said cognizance was taken on 14/7.
So on 14/8, my lord. On 14/8.
No, that is for examination of the victim.
My lord.
That according to you has been done.
Yes, my lord.
As far as completion of the trial is concerned, time is still 14/7/27.
Yes, my lord.
Then what is the challenge now?
No.
Why
I am seeking bail only on the ground, my lord, because dates have been fixed. My lord, he is inside. Without instruction, the lawyer is cross-examining, my lord. So, my lord, on 3rd it was carried out. Today it has been carried out. Next date is, subsequent date is 5th. Tomorrow, my lord. thereafter sixth, my lord, thereafter seventh, my lord, thereafter 10th, my lord. So he will be, my lord, either coming out or going in, remaining there, my lord, without there being proper trial, without his proper instruction, my lord. That should not be possibly, my lord.
If we have to accept that argument, then in every case we have to grant bail.
Oh, my lord, I would not have said that, my lord, had it not been on a day-to-day basis, invoking the powers under section 346.
No, you can have day-to-day basis in an offense under the UP Act also.
Yes, yes.
They will be in jail.
No, my
Terrorist Act also.
lordship is correct.
Kasab was in jail 4 years.
My lord, my argument is this, my lord. I may be wrong, my lord. What I am saying, my lord, the man accused of an offense, 7-year period offense, my lord. That too, my lord, he is inside and everyday trial is being carried out despite the mandate of 35(2), because trial needs to be completed.
So you are arguing the other way around.
Exactly, my lord.
You are saying it should be a delayed trial.
No, I'm not delayed. Within 1 year.
Within
as
1
far
year.
as
So
possible.
the last date should be somewhere in the year 27.
Exactly, my lord, as a statute provides, my
So
lord.
that you get a better scope
Exactly, my
of
lord.
interacting with the witnesses.
No, my lord, that would not be, my lord. That is, my lord, that is main witnesses are over, my lord, and my keeping me in jail, my lord, mother and
That can be an argument, all right, that vital witnesses have already been examined.
mother,
There is
exactly.
no purpose
Only
in
that part, my lord.
whether victim has been examined.
Yesterday,
Yes,
it is on oath, my lord, that can be stated. Sure, Purusha, confirm this, Sabi ago. My lord, victim and mother and victim, they have been examined, my lord. Yesterday on 3rd, my lord. And that is the tenor of the act, my lord. The lady has, sorry, my lord, the victim needs to be examined, my lord. Within 1 month of my lord, taking cognizance. As per 35(1), my lord.
Yes, PP.
I have produced the scanned copy of the case record, my lord. From the scanned copy of the case record, my lord, it is not clear, my lord, whether the victim examined or not, my lord. However, since my learned senior friend has submitted, my lord, the victim and informant has already
That can
been
be on
examined,
record,
my
my
lord.
lord.
That may be, my lord, call for, my lord. So such that case, lordship will have to consider this bail application on merit, my lord. Whereas, my lord, 183 statement, my lord, victim is implicated, my lord.
And my lord, another aspect goes in my favor, possibly, my lord. That 35(3), my lord, lordship knows the latest authority 26, my lord. It has to be the rule, my lord, in all 7-year period offenses. Here, my lord, framing of charge is also 7-year period offenses, my lord. Not giving is an exception, my lord. Here it has not been given and the forwarding report is before your lordships, my lord.
Silent.
That cannot be overridden by the prosecution, my lord.
Which part?
35(3), my lord. Lordship may grant him interim till, my lord, 11th, my lord. Thereafter, lordship may decide, my lord. Because otherwise, because of non-appearance of the council in the revision, my lord, it will stand like this, my lord. I mean, the power invoked under 346 should remain, my lord. 35(2) would not be a bad play, my lord. So, my lord, only that much, my lord. And 35(3), it cannot be cured, my lord.
For that, we again have to see the CD, whether IO has recorded any reason.
My
Why
lord,
notice should not
forwarding
be
report
issued.
is to state it, my lord. Forwarding report I have annexed, my lord. Honestly, my lord, that occurs at page 20, my lord. 2021, my lord. Absolutely no whisper, my lord. Page 20. Ulia. Huh? Forwarding এখন Forwarding report would have stated that, my lord, had 35(3) been served, attempts were made. Why not served, if not served? But no mention, nothing, my lord, no whisper. Our prayer, my lord, let him face the trial, my lord, by he being outside. Let it be till 11th, my lord, and lordship would call for the LCR, my lord. And also the specific report whether 35(3) was served or not. And had it been served or attempts would have been made, my lord, it have been reflected in the forwarding report, my lord. That is the Indian Criminal Justice Delivery System, my lord.
Whether you can bring up 35(3) at this stage.
My lord.
Whether you can bring up 35(3) at this stage.
Stage, my lord, because 47, that would be the tenor, my lord. 47,
47, 48 we understand.
No, my lord, with all respect, my lord. That is my understanding of law, my lord.
Because
47,
that flows from the constitution. Whether
my lord,
35(3) also flows.
35(3) also, my lord, curtailment of liberty would be, my lord, breach of Article 21, my lord. Until, my lord, until it is clear, my lord, that it is a breach of Article 21, my lord. Violation of, my lord, 35(3) would entail bail, my lord, that is in until itself, my lord. This is the latest one, 26, my lord, that we have placed before your lordships, my lord. That would be placing before your lordships. And several untils, my lord. And apparent, my lord, 35(3) breach, grant of bail is the possibly the, my lord, there, my lord, D would be applicable, my lord. Wherein, my lord, that on new grounds, arrested, and secondly, my lord, D would be, it would be the rule, my lord. That, my lord, last part, my lord, with all respect, my lord, concluding part. Rule area hai, my lord, with all respect, my lord. My lord, conclusions. Conclusions D, my lord.
No, I want to see the constitution part. This part we all know. Where has it said it is a violation of the constitution?
My lord, 35(3) because it is in the statute, my lord, and flows from 21, my lord, because curtailment of liberty, my lord, has to be, my lord. With all respect, my lord. And statutory right, my lord, intention of the legislature reflected, my lord, honestly, my lord. And till only, my lord, 11th, my lord, lordship would seek the report, my lord, and the LCR, my lord. If lordship finds adverse, my lord, we'll let him go inside again, my lord. And by that time, trial would be over because this is the situation, my lord. Only that much, my lord. And all 7-year period offenses, my lord. What reason why he would
According to you, victim deposition of victim was when? Yesterday?
Victim was yesterday, my lord. Third. Third. Victim and our card.
My lord,
As per the schedule, my lord.
36 of the bail application, my lord. Page number 36. my lord.
Schedule has been given, my lord. Police to sure, no? Sure. It's 6. Upon instruction, my lord, that mother and victim girl has been examined on 3rd, my lord. Aji keta koshe? Today 3 witnesses have appeared, my lord. Total 5. Page 36, my lord, the schedule has been given, my lord. Oh, BIS here. Pure Asian, no?
How many there are more than one victims, I think.
My lord?
Yes, my lord. That's part the FIR, my lord.
No. My lord, framing of charge 1 victim, my lord.
1.
Let me again find out, my lord. Let me take a minute, my lord. 1 victim, my lord. Page 5, my lord. Page 32. First, second, third, fourth paragraph, my lord. Last parting lines, my lord, it appears from both statements of victim that victim implicated that accused in respect that accused threatened to cause her death if she informs the occurrence to others.
All right, we'll see.
My lord, my lord, my lord.
35 notice, my lord, although it is not clear, my lord, whether the notice was served or not, my lord. But if lordship peruse the page number 21, my lord, of the, that is the second page of the forwarding report, my lord. It is specifically mentioned, my lord, the accused being a local resident and a government school teacher has strong local connection and resources. He may attempt to abscond or evade the process of law if not arrested immediately. The nature of allegation requires thorough custodial interrogation to uncover the full context of crime, identity, any other victim, or recover any possible evidence, my lord. Although, my lord, the 35 notice, it is not mentioned specifically, my lord, but the why which arrest was necessary, my lord, that is specifically mentioned in the forwarding report. Secondly, my lord, if he is, my lord, released at this stage, my lord, from the, my lord, from the order dated 14/7/2026, my lord, the page number 36, my lord. Trial is going to over by 10th of this month, my lord. Probably, my lord.
That is why I'm saying 11th, my lord. My lord, this of until one, my lord. Several untils, my lord. One, we have a first one, my lord, with all respect, my lord. The courts will have to satisfy themselves on the compliance of my earlier 41, my lord. Section 41 and 41A of the code. Any non-compliance would entitle the accused for grant of bail, my lord. This is, my lord, I will give a printout, my lord.
That is there in the subsequent until also. That is all right.
This latest
Yes.
But my humble submission before your lordship, but only today I have been instructed to API. That my learned friend may supply a copy of the bail petition to me. File objection. 7 days time may be granted to me.
Let him be heard on 11th, my lord. If interim is granted, my lord, we'll give him a copy, my lord.
Look, before interim, my lord, let me my part, madam.
Lordship will peruse, my lord, and decide.
You have received notice, have you not?
Yes, my lord. Received notice, but it is from Dhubri, my lord. Respondent number 2 just inform.
Notice, application goes, petition, copy of the petition goes with the notice, my lord.
That is what?
That's all right, my lord. But if not, my learned friend is in difficulty, that copy will not be served to me, that I will manage it. But problem is this, my lord, in yesterday only I have been instructed to API.
Notice was served on 31st, my lord.
My lord, my submission before your lordship, I may have granted to me file objection.
For what?
For filing objection, my lord, that is my duty. That is why I have been made party, my lord.
Objection need not be written, you can submit also.
Yeah, my lord, 7 days time may be granted.
We will see.
Either written or by, yeah.
We will see.
My lord, my lord. Obligement.
But my name may be recorded. I may check for restaurant number.
It is not reflected in the cause list.
Because my lord, I have been instructed to appear. Till date, I have not filed Ukalatama.
I was appointed by myself.
My lord, Story was appointed, my lord.
If you received the
On
instructions
condition that
yesterday
we-
and you still haven't filed Wakalatnama, why should we hear you?
My lord.
You have had ample
That
opportunity.
that is what has been said to me, my lord. Because, my lord, one instruction also I can appear. But it is from Dhubri that just instruction has been given. They will come and file the Wakalatama.
Yes, all right.
Obliged.
Item 35.
My guess may be appointed, Malat. Long back steps was, Malat, but report have not received. But it was sent from our office on 14/5.
Long back, steps was taken. Again, my lord, again I have taken steps and I have taken instruction from the PP office. It was received, my lord. But
On 14/5, it was sent also from our office. It was sent on 17/5.
Aye.
Earlier. Let the ambiguous may be appointed, my lord.
OP2 is not interested, my lord. In fact, my lord, the case is, I would like to, my lord.
All right, we'll appoint an amicus. Since May, it has been otherwise. What is the purpose of anticipatory bail if we have to wait for 3-4 months for Red Hard Learned Counsel for the petition and additional PP? No instruction is available as regards service of case to the respondent number 2. And no service report has also been received back. This matter has been pending since 11/5/26. And since it is an application for anticipatory bail, further delay would frustrate the very purpose of the bail application. Accordingly, I deem it fit to appoint an amicus to represent the interests of the respondent number 2. Accordingly, everybody is available.
He was there in the T. Porasar was there, my lord. Just now she going.
Everybody is available here now.
She is available, my lord.
T. Porasar is appointed.
Let her, please.
Copy of petition be served upon her in the course of the day.
MS T. Porasar.
All right. Is the matter again on Friday, Monday?
Monday?
All right.
Unpublished. $36 charge sheet submitted.
There are two cases, Madam. For cross case is
Yes,
also
cross
there, Madam.
case- cross
The
case also-
TCR is available with regard to the cross case, Madam, which we have
No, no.
filed.
My lord, he is seeking bail in
Kajalgaon PS case 40 of the
40.
26.
In this case, charge sheet submitted, my lord.
So trial court records may kindly be called for, Madam, if charge sheet is submitted.
All right. Charge sheet submitted by CS number
62/2026 dated 31/5/26.
for the scan copy of the TCR.
From the district and session judge court Chirang, Madam. It is.
এখানে charge sheet এখানে।
Madam, deeply of the judge.
Your lordship. 38 also charge sheet submitted. This was not a call for-
Okay.
38.
38, my lord.
What do you want to do?
Yes, my lord.
What do you want to do? Charge sheet submitted. Do you want
Kindly cancel, my lord.
Huh?
For TCR, my lord, once, my lord.
TCR? All right. Charge sheet submitted by so and so. Scan copy of TCR.
PS number is my lord 46/2026 dated 10/7/26.
What is this theft?
Mother theft of rupees 9,000, the value is 9,000, my lord.
Could they appear before there? Otherwise,
Can be here not
your choice.
My lord, this, I will approach, my lord.
You'll approach.
Yes, trial court.
All right, hard. Learned counsel for the petitioner. That CS has been submitted. Already learned counsel for the petitioners. He shall approach the learned court below. File appropriate application. Full stop. Accordingly, the present application stands close to the observation that the petitioner In the event of any application being filed by the petitioner, the same shall be considered as per law. Further directed that the petitioner shall appear before the learned court below within a period of 14 days from today.
Appearance, my lord.
Upon receipt of notice.
My
What?
lord, yes, appearance.
Can we all say anything?
Consider as per.
Petition stands disposed of accordingly.
Obliged, my lord. Made to the lordships. My lord, there were two cross cases, my lord. In AB 1345, my lord. The other day case diary was produced, but the my lord injury report was not there. So therefore, your lordships, I ordered it was pleased to direct the yes, order dated 16/7/26. Injury report of Borbata PS case number and both.
Received.
Yes.
What is the FIR?
Yes, my lord. The FIR is at page number 24. No, sorry, 24 is the forwarding report, my lord. Yes, it is 13. Or rather at page 14. My lord, basically it's a civil dispute, my lord, between two warring groups. Even my lord, they themselves claim. Most respectfully, it is submitted that I had purchased a plot of land at Jonia Market. In front of my land, the shop of accused number.
Don't read it. It's a novel. We don't want to go through and of this. So we have seen it. Yes, what about injury report?
One Lukman Ali Malat, he was fractured and grievous by blunt. Weapon Malat, it is blunt and dangerous weapon. But it is blunt, it is event. One is Malat, a simple blunt. Next one is Malat, simple blunt. But lesser injury scalp also. Next is fracture by grievous.
Itu kuntu police station. দুইটাই তো বরপেটা তো কোনটো কেছ
187 বরপেটা
আচ্ছা আচ্ছা দুটা আছে না কেস
187 only we have received the CD.
No, I think lordship has directed them to get the
Yes,
injury
of both.
in
Both.
respect of Borpeta PS 206. Actually, my lord,
This is what?
2%.
Seeking, no, that CD is not received. Malat. Seeking bail in 187, that is there, Malat. That CD is received, Malat, but other CD is not received, Malat.
No, that CD was received the other day only.
Yes, it is recorded. CD of both the cases have been received.
Yes.
Then only our office.
Only injury report
Only injury report was not
Injury
there.
report is there, Malat. Injury report, Malat, they are seeking bail in this case. 187, that is there, Malat.
No. I am in anticipatory bail application number 1345.
Yes, so PS case is what?
That is item 40, that is different, my lord. I am pressing this 1345.
Yes, 1345 is 39.
Yes.
Item number 39, today's list. Yes, here the PS case number is 187.
Yes.
That CD,
Yes, so that CD is available.
in that CD, Malat.
For some reason, we call for the CD of the cross case also.
Reason being, we have also suffered injuries and two of our persons are arrested, my lord, for whom that item number 40 is there. To accused number 2 and 6, as named in the FIR, my lord, they were arrested.
Item number 40 also they are seeking bail 187 in 187. Item number 39 also they are
Yeah,
seeking
that
bail
is
in
true. In one case it's AB, in one case it's regular bail.
Yes.
Yes. So,
Popular bail for accused number 2 and 6 of the named FIR, named accused in the FIR.
But
My Lord Shahjahan Ali
the fracture is
and Abdul Qasim.
one is well as grievous, blunt, and dangerous dangerous weapon it is given regarding one person, Abdul Motin Malad, Abdul Sattar. Other persons were simple, lacerated, and all this malad.
Fracture where?
Both middle finger, forearm, and that is fracture. Bone, yes, Lokman Ali, blunt weapon, dangerous.
They are the parents, man.
Fracture on middle finger.
Malad, not fracture, radius, bone. Malad, my peruse
Where you can see son.
Malad, it is middle finger is lacerated, Malad, but it is given our bone, but I am not understanding that what bone, Malad.
Lord, injuries were suffered on both sides. That's why deliberately not producing the injury report in our case. Same thing happened last time also.
Both are senior citizens, they are not parents, father, mother, son and son-in-law, and the baby.
There is a person 85 years on our side also. He was also not.
That injury
They were
report
at
will
home.
come with death CD, Malad.
Oh, that was called for. The CD was there on the other day. CD, that's why Honorable Court has recorded it.
Father, mother, son and daughter-in-law.
My lord, basically it's a boundary land dispute, my lord. There was, yes,
Attack them.
both sides,
And
my
the
lord,
house.
attack each other. Let us not make a mountain out of a molehill.
They were at home, my lord. I'm sorry to disturb. They were at home. Both parents are, my lord, senior citizen, and son and daughter-in-law. They are not in a mood of attack. But 20 people, my lord, came with lateral influence and started attacking them. And first reason is, my lord, that they have given advance, and my lord, they are in agreement to buy that plot, 3 kotha 12 lasa. And the person, my lord, the accused number 1, he has purchased another plot adjacent to it. But in this plot, my lord, he has a hardware shop, and for last 3 years, he has not paid any rent to the owner.
Therefore, file an eviction suit. Therefore, file an eviction suit.
Yes.
Why go to police to harass us?
It's an old lady, my lord. Owner is an old lady of 80.
Police try.
Lord, there is a saying in Assamese, my lord, Katno bulim koka, sobore darisuli poka.
So otherwise, in this petition, who is the petitioner? How many petitioners?
18.
18.
Yes.
In item 39.
Yes, my lord. And in the 40, there are two persons who are inside as a regular bail 15 days. That's 60 days today, my lord. God knows where sworn the affidavit.
Has been occupied by under my paragraph 6. Rented shop operated by Mr. Abdul Motin on the land. I have already issued notice to Abdul Motin for vacating the shop and handed over the possession to Mr. Lokman Ali. Therefore, that my son people another land he has purchased, that is only 6 lasa. And I am purchasing, my lord, 3 kotha 12 lasa. Paragraph 8, my lord, that I have seen Abdul Motin on 2nd of 26 at around 1:30, entered the house of Lokman Ali, situated in Dang number Iman Patanama, attacked Lokman Ali, wife Kamala Khatun, his son Abdus Sattar Ahmed, his daughter-in-law Asma Khatun, and 1.5-year-old granddaughter Simarana Jannat.
What are you reading?
Thou Lathi,
What is that?
iron and
My lord,
etc.
one affidavit in page 83.
Page 83, my lord.
Additional affidavit.
Paragraph 8, your lordship, I can read my. Yes, the owner of the land, my lord, Srimati Chitralekha Bayan.
Page 83 of his petition.
Yes.
Additional affidavit filed by the.
Additional affidavit.
Page 83, your lordship, my kindly peruse.
Science only is in here. Peace loving person.
Got it, my lord, page 83. Paragraph 8, your lordship, may I kindly read, 8 and 9. That crowd gathered outside the house of Lokman Ali, and we found Lokman Ali and his family members in pool of blood, almost in half dead and unconscious state. Then the neighbors collected at their house along with police personnel, took them to Borpata Medical College Hospital in ambulance. That it is important to note that Lokman Ali is a peace-loving person. On the other hand, Abdul Motin is a ruffian type person indulging in violence, and further, he has not paid any rent to me for last 3 years, although he is occupied the shop. I am a widow having no financial income except the rent of the shop. Neighbors, he pays the rent, nor he vacate the shop in spite of my repeated request. This is the character of my lord. Number 1.
So do you want us to wait for the CD of the other case, or should we?
Milord will kindly have a look at page 84, Milord. The affidavit which my learned friend has read just now.
Page?
Milord, I couldn't understand this. The deponent is identified as stated by so-and-so Ali Ahmed, advocate Borpeta. What is the meaning, Milord? What is this affidavit, Milord?
Page.
Page 84.
Page 84.
The deponent on left hand side, the deponent is identified as stated by so-and-so Ali Ahmed, advocate Borpeta. Who has identified? How can this be even taken note of, Milord? And RTI, God knows whose RTI it is. Kindly see, Milord, who has identified?
Bayan is the owner of the land.
No, owner of the land is that you have stated.
Neighbor also.
But going by the nature of the identification, at least we have not seen any such identification.
They have sent them
Huh?
to medical college.
And my lord, this lady, Chitralekha Bayan, she has not lost any affair. This is not her case. Yes, she has not filed any affair before the police. But you can't make your case, strong like this. No, my lord, this affidavit, there is a serious question, my lord. At least I could not understand. The opponent is identified, I could have understood, by so-and-so advocate in front of the notary, as stated by so-and-so. My lord, here is a case, my lord. It's a simple, perhaps a civil dispute over land. Both parties are aggressor, both have suffered, my lord. There is no dispute about it. Your lordship is not conducting a trial, my lord. Prima facie, my lord, in the other case, they are in custody for more than 60 days. And my lord, these are the persons, my lord, at least police presently they are not looking for. Na? At one point of time, yes. So, my lord, having regard to the nature of the dispute, my lord, and also having regard to the fact that the injuries are there on the both sides. And kindly see the role of police, my lord. We file our affidavit on 2nd. They show that it was filed on 3rd as a GD entry, and they eventually register on 8/6. Whereas the other FIR is of 4th, and the same day they start investigating and doing everything. So these are facts to be taken note of, my lord. Otherwise, we leave it to lordship, my lord. But prima facie, my lord, I don't think these are matters, my lord, where lordship should, devote more time, my lord.
They came like dacoits. They took 95,000 rupees also. All the sections have been withdrawn. And they have attacked us on our homes, at our home. We have not done anything.
Unfortunately,
At our home, they have
unfortunately,
attacked.
police has
20
not
people
added
came
the
like
section of
dacoits.
dacoity.
20 people came like dacoits and took away 95,000 rupees and attacked them with grievous injury. Both the senior persons were grievous parents.
All right. Let's move on now. 40 you have heard. Pass orders later. We want to finish the list.
Milan, deeply up. May I please, Lordship? Lordship, anticipated bail application, Lordship. CID PS case number 15, 2025, Lordship. Kindly place FIR 11, Lordship. More than 50 candidates have submitted pass certificate in the requirement of graduate and postgraduate teacher, Lordship.
These techno-global cases are still going
Yes,
on.
yes, Lordship. That certificate issued by Techno Global.
I think that was 1 year ago.
But even my lord, the IOS obtained verified and obtained report, my lord, from the Techno Global University also. I've settled, my lord, I'll just place, my lord, because CDS case there is voluminous, my lord. So this is a note prepared by the IO, my lord.
Lordship, same FIR.
But it
Lordship,
appears that others have been granted bail already.
same FIR, Lordship, same
others,
FIR,
my lord.
Lordship, Lordship or Lordship. I am not qualified any TET, Lordship, central or state. I have not submitted any document in education department for apply in job. I graduate pass certificate, Lordship, Gauhati University at page 25.
My lord, this petitioner was granted bail, my lord, because he is not the candidate, my lord. But it is not same to the other accused person also. For example, my lord, this present petitioner, my lord, he is one of the candidate, my lord.
My name is not FIR, Lordship. I have 50 candidate, more than 50 candidate.
He has not been, according to the IO's note also, he has not been accused of using it. But there is a list sent by the board of 300 candidates who possess certificates from this Techno Global,
My lord.
and he is one of them.
Yes. His name appears in the third list, my lord.
So as long as he does not use it,
Lordship is same
the
FIR.
question of using force that genuine
Lordship.
will not arise.
Same FIR, I have a Lordship or Lordship.
No, that the person, my lord, that my learned friend is referring to, my lord, he was granted bail because he was not the candidate, my lord. He was.
I think he is also not a candidate.
His name is there, my lord.
I am not a candidate,
His
Lordship.
name is there in
In
the
FIR.
third list, my lord.
Lordship, my graduate pass certificate issued by the Gauhati University at page 25, Lordship. I have not submitted any document, Lordship, in education department or apply in job. I have not qualified the TET, any TET, central or state. See my pass certificate 20 page, page 25. Issued by Gauhati University.
This list of 300 candidates submitted by the School Education Board. Where has this list come up from? From the applications filed by the candidates or what?
They have applied for my lord, graduate teacher, my lord, for the graduate teacher and postgraduate teacher, my lord. While on verification, my lord, that has come to the knowledge of the my informant that the my lord certificate they have produced.
But what is the name of this one?
Graduate and postgraduate teacher
Gulab-
lordship apply for job must be a qualified candidate of a central TET and state TET. I am not qualified central TET or state TET. So how can I apply the job?
But he appeared, is it not? He appeared before the IO.
He has appeared.
Yes,
before the-
I am appear before
His
the
statement also recorded and from his statement also, my lord, he has admitted, my lord. Yes, he has applied, my lord. And he has also, my lord, filed those application form, my lord.
So if he has admitted, what more will you get out of him now?
My lord, that investigation complete, my lord. Whether he is, my lord, entitled to, my lord, the privilege of PRS bail or not, that is to be from the case there. The IO has collected sufficient materials, my lord.
Far as we remember, some of them were allowed, some of them were rejected earlier, depending on the role.
On my learned friend is one of the order of this honorable court, my lord, what that my learned friend is referring to, my lord. He was the person, not the candidate, my lord. He was probably the middleman, my lord, who has, my lord, felicited the other
according to
candidates.
FIR. According to FIR, I am not candidate. My lord, graduate pass certificate. My graduate pass certificate, my lord, issued by under Gauhati University.
What is his statement?
Need to do.
It was only for net practice that you wanted a certificate. Eh?
Mainly, my lord, he has done, my lord.
Other matters also where we have, we'll see. Idea itu, silo boleh. Yes.
Item 44.
Lordship submitted, my lord. 44.
He said maybe called lordship. Otherwise, the allegations are very vague against me.
Vague against you?
Yes, your lordship. The two accused persons who have been alleged to bring the cattle in their vehicle in Baleno, 4 of cattle have been somehow fit and brought. They parked their car in around the premises of my house and the cattle were seen roaming around there. Then I have been implicated because there are many complaints of cattle theft. That is what the IO have
I
written
have
in
seen
their
in
forwarding.
other city, I have seen was photographing in Alto car even malat cow.
One, not one, two lordship. 4 ox, 2 ox and 2 cows, lordship. I am anyway not the person who was in the car. I am the person around whose premises the car was found and the cattle were found.
Already, CS submitted by CS number, scan copy of CS.
Dated 30626. 4226, 30th of June 26.
Obliged, lordship.
I'm sorry, Mala, the report was called, but that is not yet
This
received.
matter became infectious matter. That became infectious matter.
Infectious.
Yes, my lord.
Learned
Case was
counsel for
filed
the
in another case,
petitioner
my lord, and they will be
submits that
arrested.
the matter has become infectious, accordingly dismiss as such.
Obliged.
47 also. Oh, sorry, Mala, CD not yet received. CD not received.
I'm not on interim, my lord.
All right, so you did not receive list again on showing that it.
Interim, my lord, till 10.
Huh?
Can I pray for interim, my lord?
Maybe,
Is the secretary of
maybe on next Tuesday, 11, my lord.
11.
my lord. Oh, no, no, my lord.
Please, your lordship. Here, the petitioner is a government employee, my lord. Now he has been working as ASI of police, my lord, in traffic branch under the Sanctuary Police Station. My lord, kindly turn to the FIR. But before reading the first FIR against which I am seeking bail, my lord, the another FIR I am reading, my lord. Page 18, my lord.
CD is there.
He is cooperating, Mala, this statement also there, Mala, that is there. Mala, he is a police personnel, Mala, in another case for getting the MSCT claim. It was shown a vehicle is involved in that case and it was succeeded also. Mala. His involvement, or he was the IO in that case. The son, subsequently it was accident was shown.
We will cooperate, my lord. All the matter will depend upon the documentary evidence, my lord.
He was transferred subsequently from that place. My lord.
No, there was no interim.
No, earlier also he has appeared.
He has appeared.
He has appeared. His statement also available in the city.
And what is the problem now? Yes. Learned counsel for the petitioner. LPP, this is an application under so and so. The allegation against the present petitioner, who was the IO in Pulansbury PS case number 57 of 2024 under section 279/304 within bracket capital A IPC. That he colluded with the claimants in the connected MSCT case, being MSCT case number 351 of 2024. Accordingly, submitted a charge sheet to claim insurance money, paying compensation from the insurance company. Submitted by learned additional PP that IO had in course of investigation, IO had the present petitioner had appeared before the IO many times.
IO.
Many times.
Hello?
Many times.
No, one time.
Before the IO, and his statement has also been recorded. What is the stage of investigation now? Charge sheet?
Charge sheet not yet laid, my lord.
Above it appears that although that the petitioner has been cooperating with the investigation and the IO has not seen any need to take the petitioner into custody. Having regard to the above, the arrest bail is now directed that the petitioner, in the event of his arrest in connection, 50,000 surety, further provided that the petitioner shall continue to cooperate with the investigation.
I am obliged.
In this case, we have taken justice and but no instruction is received as on date.
Can't follow you. What are you saying?
In this case, the Honorable Court is directed to take the justice service, But no, we have taken, but no instruction is received as on today. So kindly allow up further 2 weeks time to obtain it.
You have taken dusty service, but instruction is needed.
Yes,
Either you have served or you have not served.
served only, but no instruction.
You have served, you have to file an
Yes,
affidavit.
If any, we need to file affidavit, but no instruction is received as on today, Malaysia.
That counsel for the applicant submits that dusty service has been affected, but has not received any instructions. File the affidavit. Place the matter again on 2 weeks.
In that case regarding vacation, there is a sine die order, Lordship. So sine die order was on the basis of an order of a Supreme Court, which is not at all related to this case, Lordship. So we have filed an application that was something different. And in that case also, Honorable Supreme Court has clarified that that order will not be a precedent. So that part is there, Lordship. One more thing, Lordship. I have filed all the 14 IA Lordship, but all are not being tagged today, Lordship. These 10 are not being tagged, Lordship. Only 4 are tagged. These are not. So I have also one prayer, Lordship. Lordship, the matter, these are not tagged, Lordship. These are numbered, Lordship. All are. Hello, I'm also as a prayer, Lordship. Kindly detect all the matter, Lordship, because in some of the cases I could not find the advocate, Lordship. I have said it. I could not find advocates, Lordship. The petitioner advocate, Lordship. I signed it in the before the registry that I will serve. I am praying for detecting all the matters, Lordship. Detecting all the matters, Lordship. But the listing on the same day, Lordship, but detecting will help it to adjudicate the matter, because Lordship, the matter is there.
In the cases are listed on the same day, what does it matter if it is tagged or detected?
If in some cases advocates may not appear, Lordship, in my humble understanding, all the advocates are not appearing, Lordship, of the petitioner side.
So which to be detected from which? All the cases to be detected.
Detect, Lordship. All the cases has to be.
All are similar.
Not similar, Lordship.
Tagged together with a.
Lordship, I have filed separate IA, Lordship, for all the petition. Everybody has to
But we have-
separately, Lordship. But the same question cannot be raised. I have not filed one petition, Lordship. I have filed 14 petitions. So they have to argue on the 14 petition, Lordship.
Whatever, we will argue, your Lordship, but.
On the one hand, you say these are to be listed along with this.
No,
On the other hand, you say
this has
these are to be.
No. This has to be listed in connection with petitions also, criminal petitions. These are the IA filed in against IA Lordship. 14 petitions, I have filed 14 IAs. So there is no question of arguing it together, Lordship. On each matter, they have to argue each, Lordship.
So these IAs are in connection with the cases which are listed today,
Yes, Lordship.
but they have not been brought on
14
record.
These are the 14.
The case is not yet numbered. We have not got the number.
No, numbered, Lordship. All are numbered, Lordship. These are being numbered. I filed around 20 days ago. It is being numbered, and I don't know why it is not being listed, Lordship. These are the 14 cases numbered, Lordship. This is not filing number. This is numbered.
My matter is, for example, it is not listed here.
Anyway, in any case, after looking at the names of the personalities involved, I am unable to take up the matters. Because during my tenure as law secretary, I had to deal with the files of these gentlemen. So,
Lordship, the fact is that this matter is being stayed on an order which does not relates to this petition, Lordship.
That is a matter of.
That's a matter of
He cannot
fact.
say
But
like
it-
that. That has to be.
This is the content
Opening the
of,
file, how can we?
this is the
Oh, that-
contention of my petition, Lordship.
Okay,
Finally,
item 51 to item
51 to
64.
64, Lordship. The interim order, maybe the detagging will help to the department. We are also.
Tagging, detagging, okay, let it be left to the wisdom of the court, which will take up the matter on merits.
And let it come on Friday, Lordship. I'm urgently, Lordship,
Okay,
because
Friday. Along with,
all these things.
Yes. give this list, along with I number so and so. List is there.
Friday.
For another bench without me. Yes.
Interim order.
Interim order to
Can it be
continue
on
till the
Monday?
next date of listing.
Subject to Lordship's convenience, can it be on Monday, Lordship? Subject to your Lordship's convenience.
I have, my convenience is over.
Or Friday is okay, Lordship. I may not be there, Lordship.
On Monday, Friday, if you have a prayer, you make it on that day. Because
Friday, Lordship.
Keep it.
Highly obliged, Lordship.
yes, they have to continue the next date of listing.
Here in this case, Lordship, two criminal petitions are there. One in which I have challenged the maintenance order, and the other side has filed one criminal petition that for enhancement of that order. Here, Lordship, what I am praying for this honorable court is that, Lordship, the case was filed in the year 2021. And there was some subsequent development also. Lordship, I have instruction to withdraw this application and with liberty that he will file an application under section 127 for modification of that order, Lordship. The order is also there, that may be also vacated, Lordship.
On the prayer of learned counsel for the petitioner, the matter is dismissed on withdrawal with leave to prefer appropriate application before the appropriate forum. Yes.
And Lordship, another
Interim order,
application,
if any, stands vacated.
the other application filed by the respondent wife, Lordship, for enhancement, probably that 482 will not come because, Lordship, that 127, earlier 127 is there. So they have to file application for that enhancement, Lordship. So let them come, he's on leg, he's coming.
That is with regard to item?
That item 76, Lordship.
76 chalo pichot mat aha nai niki.
And all, and otherwise also, Lordship, they had challenged the learned session judge order, which was passed in revision petitions. And the learned chief judicial magistrate initially allowed, Lordship, 14,000, and that was reduced to 12,000. So even if they succeed in this case, that will be only to that limited extent of 14,000, Lordship.
You are submitting on which item? 76.
76.
Let him
So-
come if it is.
The alternate remedy is there. My submission would be, Lordship, regarding maintenance, because alternate remedy is there.
He has come
127.
seeking enhancement
Yes.
without approaching under 127.
Let him come.
He has come, he has come.
Here, he has come also.
Yes.
আমাকে withdraw হয়েছে।
My lord, my case was filed by the wife, my lord, for my lord, increasing of the maintenance amount, my lord. So, my lord, the matter was heard, my lord, many a times, and was listed for hearing also many a times for disposal, my lord, but it could not be, my lord. So, my lord, if possible, it may be disposed of today, my lord.
No, he has raised an objection that you have not approached the alternative remedy under 127.
My lord?
Alternative remedy is there. My submission was that, Lordship, the initial order was passed in the year 2021. And he has filed this criminal petition in the year 2023 showing some change of circumstances. And for that, he
This
has
is purely under 127.
127 CRPC, he has to file one application.
How can you challenge that order 2 years later?
Yes. তাতে CRPC 127 তাতে file কৰিব লাগিব।
It is better you apply under 127. We'll grant you the liberty.
My lord, no, my lord, I have to see, my lord, I have not gone for them to take instruction also, my lord, and then that case, my lord, the date may be fixed, my lord. Short date may be fixed, kindly, my lord.
Why have you come here without seeing the file?
But my learned friend has raised the issue now, today I first time heard, my lord, I have not. I have
Did we
not-
invite you for a cup of tea?
At this stage of fact end of hearing stage, my lord, he has raised the issue now, the maintainability of the, which ought to have been, my lord,
I will raise
taken
the
in
issue
past,
at
my
the
lord.
time of hearing only. I cannot discuss these issues with him also. I have to issue.
Suppose he has not raised, court raises. What is your response?
Definitely I have
We are
to,
raising it.
if you had proceeded, I have to answer, my lord.
Yes.
I will satisfied, my lord. So, my lord, on that issue, I have not gone through, my lord. So, my lord, a date may be fixed, short date may be. My lord, this case is pending for, since my lord kindly see for 21.
That is why we want to dispose of it today.
My lord, if it goes to the back to the lower court, my lord, perhaps you will not get in this life also, my lord. Because it is already 10 years, my lord, since 2016, my lord. She is suffering and suffering, my lord. Some amount is given, order to be paid by honorable court only. That's why she has got some amount. He is not willing to pay a single penny, my lord. If it is returned back, my lord, it will take another 10 years, my lord, to get decided, my lord. This husband is so, my lord, smart and enough, my lord. He is make all the pleas to delay the matters, my lord. So, my lord, let me to, my lord, see, my lord, what learned plea, my lord, learned is sitting in the plea, my lord. On the next date, I will satisfy your lordship, or your lordship will be pleased to send back, my lord.
We are not talking about sending back anything. We are talking about why should
A
you?
short date may be missed in that case, my lord.
All right. Next Monday. Tuesday, next Tuesday.
Next Tuesday. 11. Item 75 disposed of.
Yes.
Lord.
My lord, may it be on 13th, my lord. May it be on 13th, my lord.
All right, 13.
All right.
Hey, 75 wishes, 76 to 13. Both 75, there is an IA and criminal petition, both are disposed of.
Yes, the main case is gone and I will be, in view of the main order passed in that I will be disposed of.
75 main case to criminal petition order to likhibo aru IA likhibo in view of order passed.
Obliged.
67.
Probably the lordship. My lord, I'm a businessman. I'm doing the business of advertising agencies. And then I'm a name and style, Hype Communications and Marketing Consultancy. So the respondent is known to me. Sometimes he takes anger from me at the pendant. On 3/4/2015, the respondent approached me. Here, in this case, I'm the accused person and he's an informant. Respondent is an informant. So the petitioner asked me to take on hire a ready-made steel hanger that is a pendant and its accessories for putting up a pendant at Aizawl, Mizoram for the purpose of any trade expo. So accordingly, I gave him the hanger on 5/4/2015 for an area of 15,000 square feet. Tail hanger consists of 15,000 square feet hanger. Boxes consist of triples and other things that is required for the pendant. Then on that day, really I give on a delivery challan. On 5/4/2015, he signed on that delivery channel containing the items, whatever is there. That is the Annex 2. Substantiate that I am the businessman. I have given the trade license as Annex 1. And
delivery challan is it, I have got a original book of that delivery challan, my lord.
Yes, I think we have gone through all this
Yes,
on the
yeah,
last
right,
occasion.
right.
Why did we, for some additional submission, why did we keep it?
Due to paucity of time, up to 4:45 Lordship heard the matter. That's why maybe Lordship fixed the matter today as a part heard.
Yes, sir, let's continue from there. Instead of repeating everything again.
That
If
he
you
has
want, you
signed-
can give a short summary in writing also, but main contention is that you are the owner,
Yes, I am doing.
and in support of that, you have annexed certain documents, one of them being that photocopy,
Next two, that is the.
wherein your initial is allegedly there.
Yes, this is the original one, he has signed it, I have got a copy of that one.
Hmm.
I can give that. Because from here only I have taken the photocopy and also type copy of that.
So that is your only document.
That is only, and moreover,
That is in page?
Connected to a face.
Page number 19, my lord. 19 of their petition.
19. Yeah. I also submitted the copy of the original, how it looks like as Annex 3.
Your name is?
Pankaj Majumdar.
And he is Ranjan Buragohai.
Ranjan Buragohai.
Bhai.
Gohai.
Lordship, in annexure number 2, page number 19, the signature of the Ranjan Bhattacharya was always under dispute, Lordship, because we accepted that, admit that this is our signature. They are trying to prove or trying to say that this is my signature.
Which one, on the left?
Yes, on the left.
Yes, signed is as it is. Submitted as is signed.
My submission.
How can we decide all this?
Exactly, Lordship.
Well, my lord,
Whether it is his signature or.
What I submitted, my lord, that I have submitted that at least I have got one document. I mean, that is, he has signed it and taken from me. And for that also, we are going, the original format also is there along with that. Then out on these documents, I have got half of the item, more than half of the items from the additional DGM come to.
That depends on the
That time I have got a
circumstances. If
pendant
nobody has opposed it, then it may have got it. Uncontested, you may have got it.
Pendant consists of not only
Now,
particular.
when it is contested, then how can we decide whether this
Moreover-
is your signature or his
moreover,
signature or whose?
They have claimed, moreover, they have claimed that they have purchased for 7 lakhs, and after that, they are for repairing also, they have spent nearly 4,50,000 rupees. So that means nearly 11 lakhs 50,000. There's a burden lies on them also to show some documents, at least something. And they could not produce any document. Not only that, they have abandoned a complete claim. So if it is their item, they have spent nearly 11.5 lakhs. So at least they should have they should have filed JIMA petition to get the items back, but they are silent. And we are silent is an acceptance, my lord. And no evidence found in his case, in their case, whatever case filed out, FIR filed out, that resulted into an FR. And FR is accepted by the court below. So his contention on the FR doesn't good hold him.
Yes, I've been.
But
Just a moment.
and moreover, if it is his articles, definitely he could have claimed. And merely relying on us also doesn't look, because this is his claim that he has purchased. Burden lies on him also. And now police has given the items to him that as there is no space available in the police station. That's the only reason that is given. Now, on which authority he is holding that? And we have already got the half of the item. Only for the last 11 years, we are running for the half of the item. It is only stain hangar consists of 2,400 square feet. Rest all triples.
The
boxes.
scope, you see the scope of Jima under 451 or whatever does not empower magistrate to get into a very detailed and disputed question of it is
My lord,
limited where the owner comes, claims this is my item, it is seized by the police, give it back to me, it is not needed.
By
My lord,
This cannot enter into all these things.
That cannot be a ground, my lord. They are running for 11 years. I am also running. They are dragging me to the court, each and every court, CJM court, Sessions court, and before this honorable court.
Definitely, these items I am claiming.
Is it a ground, lordship?
Once it is come to an FR is accepted, that comes under 452, honorable court definitely can give the Jimma to us. 450. Moreover, and while disposing that one, as far as one that time it was a
It was seized from whom?
That was seized from the informant.
Him.
Yes, actually what happened, that truck came from Ajwal. Then I was loading because that item belongs to me, so I was loading. By the time he came, he had a tussle with me. Then after that, I filed an FIR and he took some item, only steel hangers, consist of 2,400 kgs. By force he has taken. Thereafter, I filed the FIR. And that items, when it is generally it happens that whenever the informant asks for the items, definitely it gives to him. But what the reason of giving is that he has no space available. Only that's the only ground which was given to him, not on merit. Now, as far as 115 is concerned, while disposing the case, the court has got the right to took some evidences even if 51 says 451 says that order for custody and disposal of property pending trial in certain cases. When any property is produced before any criminal court during any inquiry or trial, the court may make such order as it thinks fit for proper custody of the such property pending the conclusion of the inquiry or trial. And if the property is subject to the speedy and natural decay, or if it is otherwise expedient, so to do, the court may, by recording such evidences as it thinks fit. The court will should have done that.
That is what it is done.
No, they have not given, my lord. At least they court bill should
It is
have.
not a question of speedy decay.
No, and you, my lord, kindly pressure if it is otherwise expedient. Because steel hanger, though it is called steel hanger, but is made of iron, and I think now everything is corroded. Last 11 years, I don't know how he has kept it. Definitely is corroded. And he will be better, moreover in that case, status report also may be inquired, call for. And he will be knowing better the position of the items. As such evidence as may be necessary, order it to be sold or otherwise disposed of. So accordingly, this should have been disposed of. As the power given at that time, it was 451 was in force. Now after that disposal, it has come 452 also. It's come.
The case ended in final report.
Final report.
This order was
Accepted.
passed after
Accept-
this.
Yes, accepted. Final report was accepted because they have not filed protest petition even.
So 451
have
applies
filed
to
protest
only
petition.
pending inquiries.
They could have filed a protest petition. At least
Is it not?
some action should have been done there from the if this their item. Now 452 comes after the
Yes.
452. So here also order for
So
disposal of property.
451 is not applicable.
At that time it was applicable. The court will have failed to do that.
When was the final report submitted?
Final report, that copy is not with us, well, but the order it reflects. Impun order is paid at page. 67. 67.
Final report was accepted on the same day.
It is written.
Page number 72, lordship.
72, it is there.
So once it is accepted,
If the 452 comes to an 452.
So
And
here
at that time of
452 will be applicable.
we, at the time of filing, we filed under 451. I court below could have taken the action as per 151 by recording evidence and other thing and could have disposed of. That's his prime duty, because court has the link with the the police has the link with the court, and they do everything under the guidance of honorable court below. They have not done that. Court bill has not police has not done, even though court bill has not taken that action as 451 as stipulated in number 51 451. Evidences could have been taken at that stage because that section clearly says there. Now we're in the hope that we are going to get the item, we are going to get the item. But it continued like that because one after another. Now we have once we got the half of the court bill said that this is civil in
Whether
nature.
it is 451, 452, court is to deliver possession or grant custody to the person claiming possession. Here there are two persons claiming possession. Did not.
But yes, no action on their part.
But no action.
But their cases came to an end here. There is no case. They have not claimed. They have made a silent. Silent is an acceptance. They have not filed a protest petition. Or it is order is written.
No, we are not
But
on that. Cases come to an end. All right. They have not filed protest petition. Cases come to an end. The question is of custody of the seized article. So here there are two claimants.
But once they have their case has come to an end, my lord.
We filed protest petition, my lord.
No, yeah,
after receiving the
furthermore, as the
notice from
final
the
report is
honorable
accepted
court
at this stage.
regarding submission of final report by the concerned police station, we filed protest petition that was disposed of on the same day itself. At the
No,
time
my
of
lord, no, my lord,
passing
he
the
has to
imperial
prove
order.
that because order it is clearly reflected. Now, let me revert to the petition filed by the informant, through which he has prayed for directing the police to investigate the matter into the case afresh. That's the petition. Now he's telling my learned friend is telling that he has filed a protest petition. It is pertinent to note that this court has no power to redirect the investigation of this case, and that power rests on the Honorable High Court. The petition is not in the nature of format contained under section 2D of CRPC. In order that it could be inferred that it is in the alternate, he wants to proceed with the case on his own. I have gone through the materials on record and the case diary, as well as I see no reasons to proceed with the case. Accordingly, the final report submitted by the investing officer is accepted. That's the reason, my lord. Now, at this stage, if he verbally submits that I have filed a protest petition, that is not going to work. And moreover, moreover, they said that they paid money. There's no document from their side at all. And in that court below also, in one form, my lord, it is pertinent to note here that it is submitted on behalf of the informant that the informant has enclosed various documents along with the truck details where the materials were transported from Aizawl to Gauhati. I have found no such document in the case record. They have failed to produce any documents. Those said they already submitted the documents, but they failed to produce any document. At least once they're claiming, they should have shown something, some sort of evidence, some sort of document. Because burden lies on them also. At least I have got some documents, and
with the averments, with the other submissions on their will, everything comes in our favor. And by saying it also, we have got the Zimma of the items on the same documents, on the same facts. Cannot be said that additional CGM was wrong.
Page number
And what will
68.
happen to that order?
Page number 68, my lord. Third paragraph from below, my lord. My learned friend said that we have not filed any protest petition against the final report submitted by the police. The observation of the learned court below. Third paragraph from below, page number 68. Yes, may I read? In the meantime, on 12/12/2018, the informant filed objection against the final report submitted by the police and prayed for directing the police to investigate the case afresh. We filed our protest petition. However, it was rejected and the final report was accepted in the impugned order. I have submitted that we have submitted our protest petition. He said, I have falsely submitted before this honorable court. This is the observation of the learned court below. My submission is that, Lordship, from day one, they have claiming that they are the owner of some property, steel hanger and other products, which are clearly mentioned as per their averments in page number 19 and annexure number 2 of their petition. Page number 44 is the FIR in which they filed their Zimma petition. In that FIR, I was the informant. The respondent number 2 was the informant.
Page 44.
Yes. Page 44 is the FIR in which they filed their Zimma petition. This is the story projected by the respondent number 1. May I read your page 44? This is the FIR filed by Ranjan Borpatra Gauhati, the respondent number 1.
Yes.
May I read?
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই শ্ৰী ৰঞ্জন বৰপাত্ৰ গোহাঁই পিতা সয়েন্স ৰেচিডেণ্ট অফ সয়েন্স ঘটনা বিৱৰণীত মই আপোনাক অৱগত কৰিব বিচাৰিছো যে মই এটা লোৰ ষ্ট্ৰাকচাৰ পেণ্ডেল 7 লাখ টকাৰ বন্দোবস্ত কৰি হাতীগাঁও পুবৰিয়ন পথৰ নিবাসী শ্ৰী পংকজ মজুমদাৰৰ পৰা 7 লাখ টকাত কিনিছিলো পেণ্ডেলটো কিনাৰ পাছত মই মিজোৰাম আইজলৰ হোৱা প্ৰদৰ্শনীলৈ পঠাইছিলো পেণ্ডেলটো আইজলত স্থাপন কৰাৰ দায়িত্ব পংকজ মজুমদাৰে লয় He took the responsibility to install the entire pandal aisle.
After selling
After purchasing from him, he also used to install everything for a particular phase. So he said that I can install it in aisle. So I gave him the contract to install it in aisle. Shri Pankaj Mojumdare মোক বেয়া আৰু নিম্ন মানৰ পেণ্ডেলটো বিক্ৰী কৰাৰ বাবে পেণ্ডেলটো প্ৰদৰ্শনীৰ স্থলীতে খহি যায় ফলত পেণ্ডেলটোৰ ভিতৰত থকা প্ৰদৰ্শনী দেখুৱাবলৈ অহা সহযোগীসকলৰ বহুতো আচবাব আৰু তাত থকা বস্তুসমূহ নষ্ট হয় সেয়েহেতু মই সহযোগীসকলক নষ্ট হোৱা বস্তুবোৰৰ মূল্য ভৰিব লগা হয় তাৰোপৰি চলিত প্ৰদৰ্শনীৰ বাবে পেণ্ডেলটোত পুনৰ মেৰামতি কৰিবৰ বাবে মই পংকজ মজুমদাৰক বহুবাৰ কোৱাৰ পাছতো তেওঁ নকৰিলে যাৰ বাবে মই আইজলৰ মানুহ লগাই পুনৰ পেণ্ডেলটো মেৰামতি কৰাৰ বাবে 4,50,000 টকা খৰচ হয় প্ৰদৰ্শনী শেষ হোৱাৰ পাছত শ্ৰী পংকজ মজুমদাৰে আইজলত উপস্থিত হয় আৰু অতিৰিক্ত খৰচ হোৱা ধনখিনি মোক ঘূৰাই দিম বুলি কয় পেণ্ডেলটো যেতিয়া মই আইজলৰ পৰা গুৱাহাটীলৈ লৈ আহোঁ পংকজ মজুমদাৰে জোৰ জবৰদস্তি পেণ্ডেলটো অনা ট্ৰাকখনৰ ড্ৰাইভাৰক ট্ৰাকখন ৰুক্মিণী গাঁৱৰ তেওঁৰ গুদামত বস্তুখিনি নমাই থাকে সেই মুহূৰ্তত মই সেই ঠাইত পাওঁতে পংকজ মজুমদাৰে মোক মাৰধৰ কৰে সেই সময়ত আপোনাৰ কৰ্তব্যৰত আৰক্ষীয়ে আহি পায় ট্ৰাকখন থকা আধাখিনি বস্তু দিছপুৰ থানালৈ লৈ যায় গতিকে মহোদয়ক প্ৰাৰ্থনা কৰি জনাও যে দোষী সাব্যস্ত বিহিত This is the complaint made by the respondent number 2 here. He claimed that the iron structure was purchased by him. We are not disputing that there are some other triples, some other materials and boxes are there, iron boxes. For installation of that, those articles are necessary. That articles maybe belongs to him. He filed a Zimma petition before the court below. The court
allowed him to take the Zimma. We have no any objection because we are never claiming the that particular article which were seized by the police and given custody to him. We are claiming our iron structure only, and police gave me the custody from the police station itself. Now, for a moment, for argument's sake, Lordship, we said that we are not the owner. For argument's sake, he is the owner of the iron structure. So, whether the annexure number 1, 2, and 3 are the sufficient document to satisfy the landed court below to prove his ownership. Normally, when we file a Zimma petition before a competent court of law for any mobile phone, any car, or anything, we have to prove our ownership by showing the RC, showing the cash memo, something to prove that, yes, I am the owner of the property. After prima facie satisfaction, court call for a report from the police station. If the concerned officer in charge says that, yes, this particular article is not necessary for further investigation, then by executing a bond, the police handed over the custody. Court directed the police to hand over the custody. Here, they produced 3 documents before the landed court below. One, Annexure 1 is the trade license issued by a municipal corporation. My question is whether the municipal corporation is an authorized organization to give ownership or certify ownership of some person. No. Annexure number 2 and 3 and Lordship already gone through. This is a disputed signature, Annexure number 2, and what is Annexure number 3 is a blank document. They know why they have annexed this before this honorable court as well before the court below. Only 3 documents. So if they are the Zimma petitioner, if they fail to prove their own case before the court of law, and after a full-length hearing, if the landed court below observed that it is a civil dispute between the party and a competent civil court can decide the ownership between the party, then what is the wrong, my lord? Whether this honorable court can grant Zimma to him on the basis of these 3 documents, trade license and other 2 documents. They are saying that why I have not aggrieved against the impure order where my final report was accepted. I filed an FIR before the concerned police station. In that FIR, the police gave me the Zimma. I accepted. I admitted that the steel hanger was at that time in my possession. So, if the court accepted the FIR, I don't want to continue this. Therefore, I have not agreed. They are expecting 2 things. That first, why I have not submitted any document to prove my ownership. First, this is their Zimma petition. They have to first prove. If the court satisfied with that, then if the court asks me, they show us some document from your side. See, these are the documents. Prima facie, it looks like they are the owner. Then I will produce something. By a trade license issued by a municipal corporation in the trial court also, they produce the same 3 things. And secondly, they are expecting that the final report submitted by the police, which was accepted by the landed court, I have to agree against the higher court. No, my client is not interested to go further. This is purely civil dispute, Lordship. Now they know they cannot go to civil court. It's a huge gap from the cause of action. Therefore, they are lingering the issue and harass me by dragging from each court to another, from sessions court, again trial court, again before this honorable court again. But my submission is that this petition may be rejected with exemplary cause, my lord.
My lord, I have got some observation in this point. If their perusal of the affair, whatever they have filed, it can be ascertained that he has purchased, he is telling now still structure. It's a new word has come. But whereas it is clearly like a pendel to kinda pisot ma Mizorama Aidolot, Zua Podoknule Pothaisilo. Pendel. My lord, pendel consists of many items, my lord. Iron structure, generally we put in a initial. Then after that, truss, post, whatever posts are there, ladders, platforms, electrical goods, rope, tools, nut bolts, clutches, mattress, blanket, tirpals. All things are there. And now he is telling in the respondent is telling that he has purchased only the steel structure. They have deviated from their statement. Finally, see the FIR. 7 লাখ টকাত তেওঁ পেণ্ডেলটো কিনাৰ পিছত মই আইজলত যোৱা প্ৰদৰ্শনীলৈ পঠাইছিলোঁ। Pendel includes everything. Now it cannot be separated. This is his statement. he has purchased a pendle, not a steel structure of 2,400 kg. This is only one item. And moreover, once I am telling this is my item, whatever document is along with me, I given, once he is claiming that he has purchased, burden lies on him also. Show some document. Simply, he will spend 11.5 lakhs without anything. How it is possible? Wouldn't man can understand that. And moreover, during the pendency, because we have filed the Jimma petition 2015, I got the items except the steel structure. Rest all the items I got. And from there, I am trying to get my items for the last 11 years. I'm struggling one after another because after that I filed a revision again. FR came, I again gone back. I have given the liberty to file there, hoping that I will get the item. But if it is two items, that is different thing. It clearly shows pendle. It includes everything.
So now the very identity of the item is also in dispute. Steel frame, pendle.
Pendle means everything. Pendle means all physics. Steel structure means whatever is there, that is he's selling only.
Whatever it is,
Yeah,
whatever is the
steel
thing, you
structure.
say, whatever is the thing that you want, you say it is with him. Is
Yes,
it not?
only structure, that is
Yes.
2,400 kg.
So why
That's
the
what-
dispute between the description now? The identity of the structure is not in dispute.
Yes, he has
Whatever
taken
you
that,
want.
that is forcefully taken by him, and police has given the custody as there is no space available. Noble court is should have disposed that structure. This is 2,400 kg, which is a part of the pendle. If he has purchased, he should have shown some document that is apparent lies on him also. And he is keeping
Your
pendants
application was for what? This 2,400 kg steel structure.
structures.
Your
But-
application was for that.
Yes. Absolutely.
So what is the dispute with regard to that item now? You are saying pendle structure. What is the
The
meaning of
pendle
that?
means there are submission that they have purchased a pendle. That means they have purchased everything. Everything means steel structures, thus
Okay, so it is inclusive.
inclusive. So rest of the things I got. Jimma, I got the Jimma. Honorable Court has, court bill has given the Jimma to me.
Hmm.
Now only steel structure was there, which was seized in 21020 case of 2020, 2015. Because I have to have that item also, otherwise there's no use. That's why I'm claiming, being an owner. And they will leave everything, he's not interested, they will leave everything, I am not interested, I don't want that, how it can be, 11.5 lakhs, my lord. 7 lakhs plus later on for repairing, spend nearly 4.5 lakhs. Can it be believed? And moreover, the case has come to an end. Police has submitted the FR, accepted that. So it means there's their content, how it holds good. Whatever is content is there in the FIR.
So if he is the owner of the property, then he could have produced some document, a purchase document, money receipt, cash memo, whatever it may be, for his articles. Whatever, what he has submitted, only one delivery channel.
My lord, at least I
Whether
have
a delivery
submitted
channel
some
is
documents.
a document for ownership. He said, and my throughout the proceeding, I disputed the signature. This is not my signature, my lord.
Definitely he is going to dispute it, cannot accept it.
Lordship, how can they prove that that document is my
My lord, the
signature?
court will
And lordship, they have not produced a single document to prove their ownership.
Not taking.
They have to purchase
evidences.
from a shop or from someone else. Then there must be some document that, yeah, I am the owner of this property. I purchased this for this much of amount. They fail to produce any document before the court.
My
Now
lord,
they are
at least
claiming
I
the
have
ownership of
submitted 3 documents. One is the
Trade
color
license.
and another supporting documents.
Yes, all right. I think we have heard enough. You can take this back. Oh, ready.
Pleasure.
Please, your lordship. Lordship, we have newly engaged in this case, Lordship. Oh, some instruction yet to receive from client.
You are Mr.
M. Alam, Lordship.
From learned counsel submits that he has been newly engaged on behalf of the petitioner.
Special PP wildlife, my lord.
Huh? Wild-
Alma, special PP wildlife.
Pardon, Mr. Vishnu Learned. Special public prosecutor,
My lord.
forest. Prayer of learned counsel for the petitioner. Matter again. When?
Let me fix it. Alia, boss. Please, your lordship. Lordship, may kindly find the England order at page 10. And the operative portion of this order is 19, whereby the learned family code directed the petitioner to pay maintenance of rupees 8,000 per month to the respondent. The petitioner approached this Honorable High Court. The Honorable High Court voided order dated 6/11/2024, directed to pay 50% of the awarded amount. And I am still paying that amount, and the arrear amount is also up to date, Lordship.
This is what he has deposited.
Lordship, only for 50% only deposited till date, Lordship.
Of the arrear.
Yes, Lordship.
Amount, the arrear is up to date, and the monthly 50% direction is also up to date, Lordship. Yes. 8,000 or 4,000, 8,000 was awarded by the learned family court. We are paying 50%, 4,000. Lordship, may kindly see the order that.
So you are paying that 4,000 per month.
Yes, yes, as per this honorable court's order, 6/11/24.
This order, Lordship, just.
So that part is over. That part is, we need not
Yes.
concern ourselves.
Yes.
The case is with regard to 8,000. So what is the infirmity in the order?
Infirmity, basically the petitioner is the respondent, number 2. The respondent is the sole person. They have no issue between the petitioner and the respondent. And she is living with her parent. Or she may kindly come to the impugned order at page 10. Page 12 starts from page 12, Lordship, paragraph 2. May I read, Lordship?
So any affidavits were of assets filed?
Assets and liabilities affidavit filed both the parties, but the respondent has taken falsehood regarding some statement in the affidavit, Lordship. In the petitioner also, the petitioner, the respondent has taken shelter of falsehood to the effect that the Lordship may kindly say.
You are challenging only the quantum.
Quantum, Lordship.
So you are a policeman.
Yes, Lordship.
What is your rank?
That is stated, Lordship.
His rank is constable, Lordship. Now, Lordship, posting at Dhubri, Lordship.
So admitted salary was something like 35,000.
Around, Lordship, till date, Lordship, to date, Lordship, at around 50,000, Lordship. The salary was increased, Lordship.
Admitted
finding
salary
was, Lordship,
34,000 at the time of filing the petition, Lordship.
4,000, Lordship.
Time of filing the petition.
There is around, Lordship, 50,000, Lordship. Constable salary, Lordship.
Naturally. Yes, tell us what is wrong with the order.
Lordship, they have no issue. The respondent is the only person to maintain herself. And in that view, 4,000 is sufficient for her. Moreover, Lordship, she has taken falsehood, whether after taking shelter of falsehood.
What falsehood?
The petitioner, Lordship may kindly see, the petitioner has stated that the respondent has stated that she wanted the petitioner to live with her as Ghorzamai. As Ghorzamai, I have stated, Lordship may kindly see page 27, and in my WS also, as which the petitioner refused because she has a dependent mother. He has to maintain his mother also, so he cannot live with the respondent as Ghorzamai. On the other hand, the order I have just passed over, Lordship may kindly see, the respondent says, the respondent before the counselor, Lordship may kindly see, order dated 15/12/2023. On being asked, the petitioner agreed to continue her conjugal life with the opposite party on the condition that the opposite party, namely Hatem Ali Mullah, will either have to live separately in a rented house or in the house of the petitioner, to which the opposite party disagreed. Contradictory statement, Lordship. On one hand, she says that I am demanding his house and money. On the other hand, before the counseling, she says that the petitioner refused to stay with her as Ghorzamai. Two things, Lordship. So when there is a false statement and on affidavit, whether the respondent is at all entitled to any maintenance, Lordship. Lordship may kindly see for that it comes under perjury, Lordship. When a false statement is made on affidavit.
This is a criminal revision, isn't it?
Yes, Lordship.
Against an order under DV Act.
Yes, Lord. Family court, yes, Lord. Family court. 125 petition.
So are you not entitled to file an appeal? Section 29.
May I submit, Lordship? In this ticket, Lordship, Opposite Party Council, Lordship, stated that Ghorzamai, Lordship. In this regard, Lordship, kindly see page number 16, Lordship. Court below, Lordship, rightly finding, Lordship, kindly, Lordship, below portion, Lordship, it's appeared that the case of the opposite party as
No,
per.
is this maintainable? First answer that. Council.
For limited understanding, Lordship, my understanding, Lordship, this is not maintainable, Lordship.
This is not a 482 or 528 petition. This is a pure criminal revision petition.
Yes.
Under 397.
Even revision petition.
Yes. So how do you file a revision when provision for appeal is there?
If after a final order is passed, this is a final order, Lordship. After the final order is passed.
Act.
But my
Is it under DV Act or 125?
I remember is that both the High Court as well as the Session Court has the power to entertain the petition, Lordship.
This is not under DV Act, this is under 125 criminal procedure.
Yes, Lordship, that is what I am submitting.
That is what we are not submitting. That
Sorry,
should have been
Lordship.
your first answer when the query came.
Sorry, Lordship, 125 petition I stated, Lordship. I stated 125 petition.
Don't come prepare with the brief and take the court here and there. Don't have the answer to a simple question from the court. So you filed a DV case earlier before the JMFC Dhubri. Is it?
Yes, Lordship. DB case, Lordship, pending, Lordship, before
DV case is pending.
pending.
Any maintenance is granted there. Yes, anything else to submit?
That's my.
You stated that you are on the quantum. So you are only to justify why 8,000 is grossly erroneous or whatever. Because it is admitted that she has no income, is it not?
She is living with her father, Lordship.
Father has no duty to look after her.
Living with her father. And Lordship, my humble submission is that when the.
She is entitled to lead a life as per your standard.
Yes, Lordship.
So you are enjoying 50,000 and you want to give her no more than 4,000.
I have some liabilities. So
No.
I have to.
Your first liability is to your wife.
My dependent mother and other family members are there. I have to
Gold does not
maintain
cover,
them
Lordship,
also.
under expenditure,
And-
Lordship.
And Lordship, more importantly, Lordship, whether when the respondent has taken falsehood in her affidavit, whether she is at all entitled to maintenance, Lordship, that is to ascertain, Lordship, because once someone has stated something falsely in affidavit, it becomes under perjury, Lordship.
What is stated under affidavit falsely?
Lordship, under affidavit, she has stated that the petitioner demanded money and building of the father of the respondent. But Lordship may kindly see the order I have passed over to Lordship, passed by the council or Lordship, can see. Order dated 15/12/23, wherein she has stated that the petitioner refused to stay with her as Ghorzamai or in a rented house. These are two contradictory things, Lordship. Self-contradictory.
Allegation is totally baseless.
No, these are all on record, Lordship. These are on this is the order passed by the passed in counseling, Lordship, and the other statement she has made in her petition, Lordship, on record.
Those statements already clarified this. The Honorable Court below, Lordship. Kindly see page number 16, Lordship.
So when perjury is there, whether she is entitled, Lordship. Moreover, Lordship, Rajneesh versus Neha says, Lordship, may kindly see Rajneesh versus Neha, paragraph 70.8.
Three lines, may I read, Lordship? The pleadings made in applications for maintenance and replies filed should be responsible pleadings. If false statement and misrepresentations are made, the court may consider initiation of proceeding under section 340 CRPC and for contempt of court. Section 340 is perjury, Lordship. So when the perjury is there, when the allegation of perjury comes, Lordship, the petitioner or the respondent, whoever it
So
is.
did you bring any application there, bringing that on record that she has committed perjury?
Yes, that was not brought, but and if the allegation of perjury comes and it proves, the court may also.
Ground number
Lordship.
in your revision, ground number, perjury.
Perjury, Lordship may kindly see page, ground number C, page 4. I have just stated misleading statement. Regarding Ghorzamai, Lordship.
So she stated that you tortured him, you say it is false, so that is perjury.
No, Lordship. Lordship may kindly see next. Lordship may kindly see next line. Rather, the respondent mentally tortured the petitioner by putting pressure upon him to stay as Ghorzamai in her parental house, to live separately in a rented house, leaving his widow mother. The learned family court failed to appreciate this aspect.
So where have you stated that this is false?
This perjury.
Where is it proved that it is perjury?
This is my submission, Lordship.
This is your, no, this is your claim.
As per
Rather, the respondent mentally tortured the petitioner by putting pressure upon him to stay as a Gharzamai, as her paternal house. This is your claim. This is your allegation. It may also be false.
No, Lord.
So why should we not say that you committed perjury?
Along with this, Lordship may kindly read the order of the council, Lordship.
Yes,
Council.
what is the order of the council?
Counseling order, Lordship may kindly see. Order dated 15/12. I have first of all, Lordship. On being asked, the petitioner agreed to continue her conjugal life with the opposite party on the condition that the opposite party, namely Hatem Ali Mullah, will either have to live separately in a rented house or in the house of the petitioner, or in the house of the, that means Ghorzamai, Lordship. In our language, it is Ghorzamai, Lordship.
So what is the perjury I am asking you?
That is the perjury, Lordship. If some false statement is made.
No, which is the false statement?
These two things are contradictory, Lordship. One, she says that she is demanding my building and money amounting rupees 5 lakh. On the other hand, she says that she does not want to, the petitioner does not want to live with me in a rented house or as Ghorzamai. These are two self-contradictory, Lordship. Either of these two has to be false, Lordship.
Now, which statement are you referring to? Where? Point out.
Yes, Lordship. Lordship, kindly see the petition of the opposite party respondent, case 21. Page 22, Lordship, may kindly see. Paragraph 3. Paragraph 3. That just after 1 month, the OP started torturing upon the opposite petitioner, both physically and mentally, with the ill advice of his family members, by demanding one part of building at Gauripur. Point number 2, a residential land at Dhubri area and cash amount of rupees so-and-so. The parent of the petitioner was unable to provide so-and-so. This one, Lordship. This one and Lordship may kindly see the order passed in counseling, Lordship. These are two completely different statement, Lordship, contradictory. Either of these two has to be false, Lordship. He says that I never try to bring her back in her petition, but I have several times requested him with some elderly persons, with my family members, with my parents to requested her to come back and to maintain the conjugal life. She refused all these things, Lordship. Her only demand is that I have to live separately, leaving my old ailing mother at home and to live with her in rented house or in her house. That is her demand, Lordship.
May I submit, Lordship?
Yes.
Kindly go, if those allegation, Lordship, against, kindly go through, Lordship, page number 34, Lordship, the WS written statement submitted by the present petitioner, Lordship, kindly go through paragraph number 4, Lordship, middle portion, Lordship. 1/27/2023, the petitioner called upon the persons from her parents' house at the matrimonial home at my house in the absence of me, and accordingly the persons from the parents' house and the petitioners had set upon a conspiracy and took a stolen some amount of money, which were kept after sale of landed property and gold ornament from my house in my absence, and flee away, Lordship. In this regard, Lordship, kindly see.
Which page is this you are reading? Which page?
Page 34, Lordship. Allegation, Lordship, put upon respondent, Lordship, present respondent, Lordship.
Or it is wrongly written as paragraph 3. Second part.
And in this regard, Lordship, kindly quote below order, Lordship, discussion, decision and reason thereof, Lordship. Page number 17, Lordship. Can you look, Lordship? There is nothing on record showing that after such allegations, incidents of theft, the opposite party initiate any proceeding against the petitioner, Lordship. If, Lordship, I am a thief, Lordship, they file an affair, nothing has been filed, Lordship, against me, Lordship. If this allegation is true, Lordship, how can they say, Lordship, Gorza, my so and so, Lordship?
Lordship may kindly see my evidence as DW1 at page. Yes.
My humble understanding, Lordship, the trial court has scrutinized the materials available in records in right perspectives and said finding are based on some reasoning, and hence the interference of this honorable court is unwarranted, Lordship. This present petition, Lordship, may dispose of today, Lordship, and cost may be imposed, Lordship. The petition.
My evidence, Lordship,
already Supreme Court, many cases, Lordship, laid down the, Lordship, this type of case, Lordship. The present petitioner, Lordship, is an constable, Lordship. Is an salary about, Lordship, 50,000, Lordship. 8,000 is a small amount, Lordship.
This would be divided and decided.
Lordship,
on merit.
the present, Lordship, present petition, Lordship, they are totally silent, Lordship. Entire pleading was silent, Lordship. No any effort was made by the petitioner to resume the conjugal life, Lordship. In this pleading, Lordship. And nothing has been said, they resume the conjugal life.
I have that answer. Lordship, kindly please see page 28. I have stated page 28 and page 40. Page 28. Page 28. The petitioner is still ready to continue conjugal life. In that view, the matter was sent to the counseling in the High Court also. But the petitioner, the respondent is demanding same thing.
Can you see, Lordship, the mediation order, Lordship? There is a clearly written, Lordship, the petitioner was not cooperated with the respondent lordship.
Every
They-
time I
they
came,
alleged lordship, our side lordship.
every time I came, she was making that demand only that I have to live separately, leaving my husband at home, my mother at home.
Lordship,
And as Ghorzamai, and Lordship may kindly see page 28, I have stated, my learned friend has said that I had never took any effort to bring back her. I have stated in my WS. On being heard by the opposite party, she met with the persons from the parents' house at Pokemon and requested the petitioner Aisha Siddiqa to return home along with the aforesaid money ornament. And Lordship may
lordship,
then paragraph
that's
14.
Submission lordship, they are not.
No, this is on record. How can it say submission? This is on record in my written statement, Lordship. I am reading from my written statement.
Yeah, that is your claim.
Yeah, and then
Lordship,
Lordship
yes,
may kindly
exactly.
skip page 14. Page 14. Page 14 also. The petitioner has been residing in her paternal home at her own will. The opposite party took several steps to bring back the petitioner in her matrimonial home, but failed due to
This is
denial
fact,
by
lordship.
her.
This is fact.
But failed.
These are your pleadings. These are not
Pleadings.
proof.
Yes, sir. My humble submission, lordship, this present petition may be disposed of today, lordship, because they are just, they are delay the proceeding, lordship, and harass the respondent, lordship.
Today or tomorrow, we don't know, but we have heard matter is heavy.
24.
24. CD had come. 24. None appears. Scan copies has been received. Placed again on switch.